11, and I've been told that they destroyed the record after 15 years. So I have asked the DC to issue a letter to me saying that we have destroyed the records for the past 15 years. That particular letter is forthcoming, Lordship. So I want to seek some time, 2 weeks time.
I tell you,
32. It's a review.
concern of the other side, Mr. D. Bora, counsel for the committee today. Case for an 2 weeks. Response. The Bora will counsel for the petitioner. Cover with consent of the other side. Case for adjournment, there is allowed. Please start at 2 weeks.
Interim order is something.
Interim order fast release is extended to the
Highly appreciated.
May it pleases your lordship. Lordship, with regard to
Just
item
number.
Lordship,
No, my
Lordship,
lord.
same matter.
Same.
my lord.
Oh, okay. Okay.
Lordship, with regard to item number 41, my lord. Lordship, we are going to file a affidavit in reply during the course of the day, my lord. So, my lord, the matter may come up in the next week, my lord. We have informed the other side.
Lord, only my prayer is that because last occasion there was a direction, there was the last chance.
Yes.
So if they file it today, well enough, let it be on third manner.
Lordship, kindly the matter may be taken up on fourth, my lord. Third, there is some difficulty on
I am-
part of my side.
Yes, the Bora counsel for the petitioner contradicts the file. Affidavit in opposition, affidavit in reply in course of the day today. Mr. P.K. also the counsel for the petitioner is present. In view of the circular, matter stands adjourned today, based on 4/10/2023.
There is an interim order, my lord. That may be
Interim of the past year stands extended to the release date of this day.
obliged.
Lordship, item number 48, the item has become infructuous.
48.
48.
58, my lord, matrimonial dispute, my lord, transfer petition. They have settled among
Settled the
between
matter.
themselves, my lord.
In the lower court.
Mr. D. Sharma, counsel for the petitioner, and Mr.
Which was
A. Chaudhary, counsel for the respondent, are present and submit that the matrimonial dispute between the parties have been amicably settled and therefore this matter is coming.
but there is a stay order that may be granted, madam. Dated 27/1/23.
Also petition stands. This having been rendered infructuous, interim order, if any, stands vacated.
Obliged, madam.
Your Lordship, I beg to mention one CRP,
Here for
987.
listing, give it to the court master.
Your Lordship, I beg to mention item number 51. Kindly adjourn the matter for today. My senior is out of station.
You've taken consent of the other side?
Lordship,
Have you taken consent of the other side?
no.
Then don't make a prayer. You need to pray when the matter reaches. It's a minimum courtesy you have to show to the counsel for the other side. If you have not taken consent, you can't. This is the data is there. Why couldn't you take a consent?
Item 51.
Why when he's present you can't take a consent? It's improper.
Stay order is there. Title appeal hearing is stalled. In the appellate court, lower appellate court, it was fixed for final hearing.
Okay.
Title appeal.
And just
Due to this
it has come.
interim
So
order.
what
it
is
is
the,
stalled.
on what ground the matter has come? Has been,
They want to exhibit one additional document, additional evidence. That was rejected. Against that, they have come.
that document was not introduced in the suit earlier.
Because they have not challenged the sale deed, and they want to now exhibit one Jamabandi. Already they have exhibited. Court held that the under order 41 rule 27 1A and AA, it was rejected. Lordship. No due diligence. All those prerequisites are not fulfilled. Simple.
That was in 47.
order 41, rule 27.
It's an appellate court order.
Yes, appellate court order. Their petition for additional evidence was rejected, Lordship.
Okay.
Small actually.
Okay, we'll take it up on Friday then. Which says a representative on the prayer made by counsel for the additional matter stands adjourned today. Based on 29/9/2023.
Obliged.
Interim order passed today stands extended to the next date of this time. Yes.
Please, Your Lordship. I beg to mention item number 33 with the consent of the other side, Your Lordship. I have taken the consent of the other side, Your Lordship.
Concern of the other side, Mr. Arboro, counsel to the petitioner, please for adjournment. Prayer is allowed. This after,
After vacation, Your Lordship.
this after.
Obliged.
Your vacation.
May I be
There is any
given
interim order operating? Any interim order is operating?
Sorry, I don't have the brief today, Your Lordship. There is a
Interim order, if any stands extended.
I will read the motion.
Question not there.
May I be given Lordship, I beg to mention item 5, Lordship, with the consent from other side, Lordship. The matter may be taken up after 2 weeks.
This was mentioned.
I'm for the respondent period.
Okay. Both sides are represented. On the plain with the land counsel for the petitioner. The matter stands adjourned today. This after
2 weeks, Lordship.
after 2 weeks, then that's fine. Item 5. What is the reason for making a mention?
Lordship, due to some personal difficulties, my senior could not appear today, Lordship.
No, because if you are taking you are in the motion time, if you are taking 2 weeks adjournment, then you have to make an observation that this pendency would not create a bar for the trial court to proceed.
Then Lordship, kindly after 1 week, Lordship.
Because that can't be permitted. Because the matter is pending in High Court, you will again take an adjournment in the trial court. On the both sides are represented. On the prayer made by counsel for the petitioner, the matter stands adjourned today, based on 4/10/2023.
Okay. Deeply obliged.
I beg to mention item number 10 minutes. Arthat matter. We have some issues today, my lord. So any day not today, my lord. And I have the consent of the petitioner also regarding a settlement matters in forest.
Wednesday. Both sides are represented on the prayer made by Mr. D. Google, standing also for the Forest Department. Matter stands adjourned today, based on 4/10/2023.
So we're listing it on 4.
4/10.
Oh, let's.
Daily list item number 1.
There is no representation from the parties. On a perusal of the record, it appears that the appellant was absent when the matter was previously listed on 26/3/2019, 34/2019, 17/6/2019, 29/2023. Accordingly, it appears that the appellant is not interested to pursue this appeal, and therefore this appeal stands dismissed on from our prosecution. Next paragraph. The LCR be returned.
Item number 2,
Please, your lordship, pass over the matter for a time, your lordship.
Time being. Okay, after some time.
Can it be on at 2?
Huh?
Second half, my lord?
At 2.
It will take time, my lord.
Okay, then at 2.
item number 3 for motion.
Please, your lordship. Lordship, there's a transfer petition seeking for a transfer of the
Matrimonial matter.
matrimonial matter
Matrimonial matter. Transfer.
by wife, lordship.
Mr. B. Chakravarti, counsel for the petitioner. This transfer petition has been filed under section 24 CDC, paying for transfer of the matrimonial proceedings from
FC Civil Guwahati to District Judge Bongaigaon, lordship.
family court
Family Court number 3.
number 3, Kamrup Metro Guwahati, to the court of
District Judge Bongaigaon.
district judge Bongaigaon. Notice steps in course of the day. Supreme State will be best written day.
Lordship is granted stay. Lordship is
Stay.
granted.
But take steps, otherwise we'll vacate it
Lordship.
in course of the day.
4,
May it please your lord.
Yes.
My lord, I have to file an additional affidavit, lordships. That affidavit is ready, lordships. It is being filed today, lordships. Lordships, may I pray, matter may please be taken up in next week, lordships. Next week, lordships.
This one 4/10/2020 is paid for by Mr. R. Sharma, counsel for the petitioner.
6. Item number 6.
What is the impugned order?
My lord,
There is the impugned order.
impugned
Which
order
page?
annexed 10, my lord.
10 page. Give me the page.
Page, last part, my lord. Page 84.
What are the prayers in the two suits?
My lord.
What are the prayers made in the two suits? What are the prayer? Shows the prayer made in the
our
two suits.
suit.
Both the suits.
The recently filed suit is ours, my lord. It is at page annexure 4, my lord, page 54. The prayer we have made, my lord. This starts at page 59, my lord.
But if that is your prayer,
Our prayer made, my lord, at page,
and the other suit is which one?
my lord,
176 of 2005. Which is the other suit?
2005, my lord. It is that annexure already decided, my lord. We both sides were.
But your suit will not be maintainable. In fact, section 10, it has been stayed. It apparently appears, apparently means prima facie. It appears the suit itself would not be maintainable. You see, your prayer, come to page 59.
Yes, ma'am.
Your prayer is that for declaration that the judgment and decree dated 1/8/2008 past in so and so is subsisting. Can that prayer be allowed?
No, my lord,
A
our
decree in one case is subsisting. Can there be a declaration to that effect? It is a misconceived suit.
subsisting, my lord, that degree is that annexure,
No.
annexure 1, my lord.
No. Who
page
has questioned
27.
that? Who has questioned that decree? Why would we give a decree? Why would a civil court give a decree that the judgment in so and so case is subsisting? Is it not misconceived?
That degree was there, my lord. In the appellate court is set aside the degree. Again, that matter is pending in High Court, my lord.
Then this court will
While
decide.
High Court,
Then this court will decide.
it
How
is-
can the trial court go and decide the say that no, High Court will not decide. We will decide, which is the correct degree. Civil court has been given that power.
So in view of the matter, matter is not finally decided. The question of rest judicata does not arise.
It's otherwise also misconceived.
No,
Why
my
section
lord,
10 will order it to be what you call struck of the file. It has to be the plaintiff itself has to be rejected.
No, my lord, our case, our suit, my lord, we have filed a suit for a declaration that the degree obtained by them behind our back.
Mr. Rajbhav, yeah. There is rightly or wrongly a decree.
Yes, ma'am.
You have two options.
Yes.
Number one, to file a suit saying that the decree is illegal, binding and fraudulently taken. We can understand that. You come to court and say that the earlier decree is binding. Can that the declaration be given by a civil court? Under what provision?
No,
The civil court.
there are three suits, my lord. One suit
No,
is.
whatever the, I'm asking you on with reference to 176 of 2005. You take what you call this, all the suits must be within the framework of specific relief act. You show us that the civil court has power to say that the decree is binding. I can understand a decree is fraudulent. If somebody has obtained a decree behind your back,
Yes.
it's an ex parte decree. You are not a party. I can accept that.
Yes.
But to have a decree that the earlier decree is binding, this is something I have, to my limited understanding of life, for the first time I'm getting it.
This is one part of the earlier degree is binding or may not be binding, but thing is then, my lord, there is a fraudulent approach by them. The first case, they both fought together.
For that you are saying that you have filed an appeal. After that, there is a SAO pending.
No,
Before this
we
court.
did not file any appeal, my lord.
But SAO is pending. In the order is mentioned. SAO is pending. SAO 5 of 2016.
Yes, it is filed by them, my lord, without making us party. Together we fought out a case, my lord, in the first court. It
Where
was
is the prayer in
beginning
that suit? Where is the prayer in that suit? 176 2005. What is the prayer?
126, 2000. Annexure 1, my lord.
Page.
Annexure 1, page 27. That suit was filed by all of us, my lord, include ourselves and they. The 6 people plaintiffs are there. And we are the plaintiffs number 4, 5, and 6.
After that, my behind our back, they file another suit without avoiding us. And they also approved the High Court behind our back, my lord. Subsequently, we came up and made ourselves, completed ourselves. And then we came to know that the next suit they have filed.
No, what
We
is
have
the relief
tell-
granted? I am unable to find. What is the relief granted in this suit? It merely says suit is decreed.
The relief
what is the-
granted in the early past suit is, my lord, degree at page 36, my lord.
Look at page 30. What is the prayer? What you call the prayer in this suit, which you will find in the decree. In the decree, the prayer is in that earlier suit for declaration that the plaintiff has got right title interest of the property described so and so. For a declaration that the decree obtained by the principal defendant so and so in titles of 62 or 76 is collusive. For a declaration that judgment dated so and so in titles of 62 is not binding.
Yes.
And for injunction. That is the prayer.
That degree was challenged by other side, my landlord, and it was set aside and remanded back.
No, you are referring to an earlier suit. That suit has no nexus with the present relief you are seeking. Here you are saying that the relief in that particular suit is binding. That the earlier judgment and decree is not even under challenge in the previous suit.
That degree was for all of us, for both the plaintiffs and defendants, my lord. The first suit, we were a party there. We also,
But Mr. Rajguru,
yes,
there must be some connection with one prayer made in one plaint, second plaint, third plaint.
yes,
There must be some connection. What is that connection? There is a disconnect. The relief in suit number 1 has got no bearing with relief claim in suit number 2. In suit number number 3, suit number 3 has got no nexus or no proximity of cause of action with the suit number
land
1.
is same, my lord. The Sudwell land on which the degree was sought, degree is being
No, I
sought.
get it. So what I understand from your submission is that if there is a decree in one suit, you will challenge it in second suit. If there is a decree in second suit, you will challenge it in third suit. And then this third degree, which is obtained, will be challenged in the fourth suit. And it will go on and on and on.
Oh, my lord. The
No,
second
there was a old story.
the
There was
second
an old story that the son of a lawyer became a lawyer and joined the profession. And after 6 months, he tells his father that I have disposed of your old suit. And the father lawyer became angry and said, that is because of that suit that you have become educated. Is it that culture?
my lord,
How can a decree in first suit be challenged in second suit as a decree in second suit be challenged in third suit? A decree in the third suit is under challenge in the court. In SAO, you have made yourself party here. And again, there is a suit saying that the earlier decree is binding.
earlier degree may not be binding also, but thing is that, my lord, they are playing the role behind our back,
No,
depriving
I'll
us.
formulate a question and fix it next week. I'll put a questionnaire under 227, why we should not exercise jurisdiction to reject your claim. we will borrow powers under order 7 rule 11, invoke 226, 227 and put that question. A decree is binding as a prayer which is misconceived. A decree is decree. When it is not set aside, it is otherwise binding. Now, if that happens to the High Court, then what happens? Somebody will file a writ petition, obtain a mandamus from the court or a certiorari, and then file another writ petition saying that the earlier judgment and order of the court issuing mandamus and certiorari is binding.
This is the factual position, my lord. But thing is that they all together obtained a degree.
No, they may have done something, but you will challenge that decree. But can you ask for a declaration that the judgment and decree is binding? That's my question. Long and short of it, that is my question. Because if I admit this, it would give a handle to everyone to come to obtain a judgment from the court in 226, 227, and then again come to court and say it is binding. That is misconceived. If you have approached this court to become a party in SAO, avail your remedy there. You are not asking for setting aside that degree.
No, my lord, this is the plain they have filed something. Your lordship kindly see.
It will be some.
And in this plane, out of this plane, they obtain the judgment and degree, page 39, annexure 2. This we have challenged. Your lordship kindly see the plane. There only it is filed by 3 persons, whereas in the original suit, there are 6 persons. And this is an X40 degree even against the government matter. And now they're trying to occupy the land and also announcing that
I would not understand. I think it will submit for days together, then also I will not understand. I'll tell you why. You have given me a plaint of 226 of 2009.
yes,
In 226 of 2009, the prayer is to set aside 176 judgment passed in 176. And if there is any judgment or decree passed in 229, that is not under challenge in your subsequent suit. Here your prayer is to confirm decree of 176.
our subsequent suit is an Annexure 4, my lord. Suit number 290.
No. We are dismissing it.
My lord.
We are dismissing this. We will not entertain the challenge.
Annexure 4, my lord. The subsequent suit we filed challenging the X40 judgment.
No.
So,
Now you see now fourth suit has come. Please tell me the connection between one suit and the other. And vis-a-vis the prayer made in the present suit. Just tell me what is the connection.
connection, my lord, there was a decree initially passed in favor of all of us. And now it is sub judice in High Court in the South. And after that, my lord, they file another case and
No, that
obtain
second appeal against orders, which is pending before this court. Where is that plaint? Which is that suit? Which is the suit which is presently pending in second appeal? Which suit is pending in second appeal?
in second appeal, the suit is pending in, my lord, 176 of 2005.
176. So you see, now please explain it to us. 176, the decree passed in 176 is in challenge in second appeal.
Yes.
and you have filed a suit that the decree passed in 176 is binding. Can that be permitted?
Binding means, my lord, it till until it is
So therefore, you think that Munsif is a greater court than the greater in status than the High Court?
my lord, assuming that this is suit is not binding, so it is sub judice before court, it may be changed or modified or set aside. Now,
So then there will be a decree which will stop the High Court from exercising jurisdiction under 220 under section 100.
then our in the present subject matter is there, they obtained an ex parte judgment in the same
No,
subject
I am
matter.
asking you a question about jurisdiction. Can the second appellate jurisdiction of the High Court be stopped by a decree of a trial court saying that the earlier decree is binding? So therefore, don't adjudicate.
That
Now we will be
cannot-
bound by a decree not to exercise jurisdiction. Is it conceivable? As a lawyer holding the brief, do you subscribe to that? I'm not asking as an officer of the court. I'm asking as a lawyer holding the brief. No, Mr. Rajbhargi, we are dismissing it in limine. We can't entertain this.
I mean, I may be given little time, my lord. I will try to explain before your lordship some other day.
Okay, then I pose a question and then adjourn it. Mr. M.S. Rajbhargi, counsel for the petitioner. Next para. From the nature of events which is submitted by the learned counsel for the petitioner, it appears that initially the parties to the list had filed a suit which was registered and numbered as 62 of 1976, wherein a decree dated 7/7/1977 was passed. Full stop. There is another suit between the parties to the list, which is registered and numbered as TS 226 of 2009.
In this case, we are not party, my lord.
It's okay.
This is our question, my lord.
Okay, the petitioners claim not to be parties. Full stop. In the set length, number 2, there is another suit between the parties which is registered and numbered as TS number 176 of 2005. In the set suit, the plaintiffs therein had prayed for a declaration that they have right over the suit property, for confirmation of possession, and for declaration that the decree passed in TS 62 of 1976 was fraudulent and collusive and therefore void. Inter alia activity, inter alia persons. There's a third suit between the parties to this, where the learned counsel for the petitioner submit that the petitioners were not parties, which was registered and numbered as TS 226 of 2009. In the said suit, amongst others, it was stated that the judgment and the concerned Dagan Atta referred in the prayer was collusive, malified and illegal, and issued after passing of the decree in TS 176 of 2005. Full stop. Another suit between the parties to this is TS 290 of 2022. The said in the plaint of the said suit, amongst others, the prayer is prayer made is for seeking a declaration that the judgment and decree dated 1/8/2008 passed in TS 176 of 2005 was subsisting. It's posited that the decree drawn in the TS 176 of 2005 in the proceedings of TS 176 of 2005, the applicant, the petitioners herein have filed a prayer for being included in the proceedings of SAO number 5 of 2016, which is presently pending before this court. First off, therefore, if the prayer made in the readings are read as a whole, it appears to the court that that if any decree is passed in TS 290 of 2022, it would impede the power of the court. It would curtail the power of the court to exercise jurisdiction, appellate jurisdiction. To decide if the decree passed in TS 176 of decree passed in TS 290 of 2022. Which should be impermissible, which appears to be, which privacy appears to be impermissible. And therefore, the court has questioned the government counsel for the petition of the maintaining of the present CRP. This is query of the court, the government counsel for the petitioner pays for an examination. Here is allowed list after a week. Let's wait for.
Mid-page, your lordship.
Yes.
Item 52, lordship, the petitioners are the plaintiffs, lordship. They filed a suit and lordship, along with the suit, they filed an injunction application, lordship. Learned trial court, after hearing the parties, lordship, the plaintiffs, lordship, under order 39, rule 3, granted ex parte injunction, lordship. And thereafter, lordship, after appearance of both parties, the injunction order was made absolute, lordship. That is
No,
annexure
but we cannot
7.
entertain such adjournments. You have not paid costs, you have not paid
No, lordship,
adjournment.
that is
costs
item
and then-
50. Item 52, lordship, CRPIO 320, lordship.
320,
Yes, lordship.
DW was closed
Lordship,
by order dated 16/12,
lordship.
19/1 and 17/2 you are given last chance,
Yes, yes, lordship. In that case,
17/3
lordship,
last chance,
lordship,
then again 19/4 with cost,
lordship. In this
Again-
case, lordship,
again 19/5 with cost,
lordship,
again 6/6 with cost.
lordship. In this case, lordship, my humble prayer before your lordship, only one chance may be given. And in that case, lordship, the petitioner, defendant number 1 is 80 years. I have advised them to file an application for advocate commission recording evidence, lordship. He is
You
bedridden,
can't permit
lordship.
that.
Lordship.
You can't permit this adjournments. You
Only
don't
one
find a
chance,
jurisdiction
lordship,
there.
already DW
No, no, you
was
see.
closed, lordship. He
Uh,
paid
he is-
600, lordship. Cost of
Oh.
600 was paid, lordship.
Mr. Chaudhary, what I say with some sort of fun,
Lordship,
I like to smile and therefore I exercise that jurisdiction to smile.
lordship.
I have said many times in the court. You see, I suffered some issues, health issues. About 2 weeks back, I was absent for a few days. So I went to the doctor. Doctor checked me up and said that you don't have a heart. So I don't know. Last chance means I must have some heart, but that heart is missing. You see, not even you pay costs.
Lordship,
You take an adjournment after adjournment, there are 3 last chances.
lordship.
And then after 3 last chances, 3 orders for cost.
An amount of cost of rupees 600 was paid, lordship. The 300.
No,
and
11,100 is the cost to be paid.
Yes, lordship. 300, 100 and 1,000 and 10,000 was not paid.
But that
lordship.
is good. That is
It's
good
a
for the system. Your
high
client has
amount,
saved
lordship.
money.
Lordship,
Why you should be aggrieved? You see, when we allow, we will give some cost, maybe
Lordship.
1 lakh rupees now.
lordship.
So therefore, 1 lakh rupees, 11,000 by the trial court, 1,000 by the, so 11,000 plus 1 lakh
Lordship,
would be 1 lakh 11,000.
lordship.
You will not like it. So he has spent 300 rupees and saved the rest of the money. You should be happy. No, but we can't encourage that.
Only one chance, lordship. Otherwise, DW will be closed, lordship. He cannot prove his case, lordship. And
You're-
this, lordship,
you
they have
still- you see,
contested the case by filing with
As per the
state.
judgment of the Supreme Court as well as this court,
Lordship,
under 41 rule 27, you would have a right to introduce fresh evidence since it was rejected.
lordship. When there is no evidence, lordship, the additional evidence
No,
may
but
not
you
be
take the
granted
chance,
by
you
the
see,
court later on, lordship.
3 last chance with and 3 further chance with cost. How can we entertain that?
10,000 is too high for the petitioners also. He is a.
No, but if I am issuing a notice, I will put a cost of 1 lakh rupees to be pre-deposit as a precondition for depositing, for issuing notice. Even for issuance of notice, will impose a cost of 1 lakh.
The person petitioners are very poor, lordship, and this case, lordship, I am doing some pro bono case,
No, we
lordship,
can't- we
only
can't
looking at
entertain
the
that.
age of the defendant number 1, lordship.
No, Mr. Chaudhary, you can't entertain that. 3 adjournments and then 3 adjournments with cost. You don't pay the cost, you don't fight it.
600 they have paid, lordship. I have seen in the order dated 16.
No, no, I'll tell you the sequence.
Lordship, On the
DW,
day 2, 3
no, you
last
see,
subordinate
you
is,
check the first order.
Lordship.
DW was caused by order dated 16/12/2022. It says you if you don't pay, you will not get a chance.
Lordship.
Then
That I
this,
admit,
then there is a second order of 19/1/2023 and 17/2/2023 again giving last chance. Now 17/3 was fixed as a last chance. On 17/3, on a cost of 300 rupees, you are given a next date of 19/4. And again on 19/5, you take an adjournment. Cost was increased to 1,000. So therefore 1,000 plus 600 is the area. Again the case is fixed on 16/6 and again an adjournment. Then 11,000 cost.
Lordship.
So previous cost of 1,000 is not deposited. You deposit 600 rupees. And again on 15/7, next date was fixed, you don't deposit cost. And you again pay for adjournment, it is closed. So you have got more than order 17/3.
Only one chance, Lordship, is looking at the age of the petitioner, Lordship.
Can't permit that. We've been too harsh on the trial court judges. On administrative side, we are creating a pressure on the judicial officer, and not because we want it. We have seen the judgments of Supreme Court now. But Mrs. R. Chaudhary, counsel for the petitioners. Next one. By filing this revision under Article 227 of the Constitution of India, read with Section 151 CPC, the petitioners have challenged the impugned order dated 16/6/2023, passed by the learned Court of Munsif, Bongaigaon, in TS number 119 of 2021. Whereby a cost of adjournment cost of rupees 10,000 is imposed on the petitioner for filing DWs DW number for filing DWs. But defendant's witnesses. The petitioner has also challenged the order dated 15/7/2023, by which on failure of the petitioners to deposit cost of rupees 10,000 and for non-filing of the evidence on affidavit of the defendants, the prayer for adjournment made by petition number 1877 of 2023 was rejected. And in view of the order dated 16/6/2023, the defendant evidence stage was closed, and the suit was fixed for argument on 16/8/2023. The learned counsel for the petitioners has submitted that the petitioner number 1, what is the age? 50 years.
80 years.
80 years old. And she was, and he was bedridden. Where is your petition? You have said you are bedridden. Where is that petition?
Lordship.
Where is that petition?
Annexure 3, page 29, Lordship.
29. Number one was an old person and suffering from illness and bedridden and could not move. And then the petitioner number two was suffering from fever and jaundice and therefore could not make contact with their counsel for reducing evidence. It is further submitted that one last opportunity be granted to the petitioners to file their evidence on affidavit. Otherwise, their valuable right in respect of the suit land would be lost. It is also submitted that the petitioners are ready and willing to deposit the cost which was imposed earlier by the government trial court. And accordingly, the Grand Counsel for the petitioners has paid for a issuance of notice and to stay the proceedings. And upon hearing the respondent, to grant an opportunity to file the defense evidence, the defendant's evidence. That's correct. On the perusal of the record, it appears that the London trial court had fixed the suit on 16/12/2022 for submission of a copy of order of this court in CRP IO 38 of 2022 and for defense evidence, the defendant's evidence. The order of this court was produced on 16/12/2022 and the suit was fixed on 19/1/2023 for DWs. The matter was next listed on 19/1/2023 and on the prayer made by the petitioner's side, matter was adjourned and the case was fixed for DWs on 17/2/2023. The prayer for adjournment made on 17/2/2023, the last chance was granted to the petitioners for filing DWs on 17/3/2023. Again on 17/3/2023, on a prayer for adjournment made by the petitioners, prayer was allowed at a cost of ₹300 and case was fixed on 19/4/2023 for DWs and cost. The petitioners again paid for an adjournment on 19/4/2023, which was allowed at a cost of at a further cost of ₹300. And the suit was fixed on 19/5/2023 for DWs and payment of cost. On 19/5/2023, the petitioners again paid for an adjournment. But as per the court order, no one was present to move the said petition. So, nonetheless, in the interest of justice and fair trial, one final opportunity was granted to the petitioner to file the evidence subject to payment of cost of rupees 1,000 at the fund of DLSA Bongaigaon. And it was made clear that on failure, necessary orders will be passed by the court. On the date fixed, i.e. 16/6/2023, the petitioner's side deposited a cost of rupees 600 as per orders dated 17/3/2023 and 19/4/2023. But no record was produced to show that cost of rupees 1,000 were deposited with the DLSA. However, on the prayer made by the petitioners, the matter was again adjourned by directing the petitioners to deposit a further cost of rupees 10,000 at the fund of the DLSA Bongaigaon and to file evidence on 15/7/2023. On 15/7/2023, again a prayer for adjournment was made to file defendant's evidence, which was rejected. Said two orders dated 16/6/2023 and 15/7/2023 are assumed in this revision. Next paragraph. The narration of adjournment mentioned herein before discloses that the petitioner's side, i.e. the defendant's side, had been granted adjournment more than what is prescribed. And the provisor to order 17-1 CPC despite costs being imposed, the petitioners did not file their evidence on affidavit by taking note of the enhanced cost imposed from time to time. Under such circumstances, when the cost imposed by the Learned Trial Court was not paid till date, the court is of the considered opinion that there is no, the orders impaired in this revision does not suffer from any jurisdictional errors. Next, under such circumstances, the court is disinclined to exercise its disinclined to accept the challenge made to the orders impaired in this orders dated 16/9, sorry, 66/2023 and 15/7/2023 passed by the Honorable Munsif at Bongaigaon. Accordingly, this revision petition stands dismissed at the motion stage. without issuance of notice on the respondents.
Yeah. Next one is lordship, the petitioners are the plaintiffs, lordship in this case. They filed a suit, lordship, and along with the plaintiff,
No,
lordship,
you'll have to withdraw this and you file a separate, this is an, against injunction you have come under 227.
lordship,
That would not be maintainable.
sometime 115, lordship, or
You will have to either alter
your
this
lordship can
first. and-
convert it, your lordship. This
Okay.
is also a revision and lordship can convert.
No, it has to be done by the registry. The central registry, unless it is corrected, we can't have the alteration done. So this is 321 CRP IO. That will come as a regular revision. It has to be renumbered and then it will come. On the claim made by Ms. R. Chaudhary, counsel for the petitioner. She is permitted to move the registry to for correction the cost rate of this application to make it as a revision under article under section 115 CPC. Instead of being being registered as an application under Article 26 of the Constitution of India. There is allowed.
Lordship,
The
may I free to list this matter on Friday, your lordship? I have some
no, do
urgent.
it immediately. It will come.
Lordship,
The necessary corrections should be done in the presence of the concern the concern section. First of all, upon correction being made, the matter should be immediately listed before the court.
keep your place.
54,
Impugn order is at page 70, lordship.
Page
Page 70, annexure 6.
impugning was allowed and amendment was rejected.
Amendment was allowed so far pleading, but so far amendment of the prayer portion, that was rejected.
What is the prayer made? Show us the prayer.
Prayer
What was the prayer made?
application at page 59, lordship,
59.
and relevant page at 64, lordship. Earlier two scheduled properties left out, that to include that properties.
Where is your original prayer in the plaint?
Plaint at lordship. Page 28, lordship.
H and I was included.
Yes, lordship. H and I was.
Says the counsel for the petitioner. Petitioners. Next paragraph. This revision, by filing this revision under Article 227 of the Constitution of India, the petitioner has said the order dated 31/8/2023 passed by the Honorable Civil Judge.
Junior division.
It's called Civil Judge or it's called Munsif?
Now it is civil the junior division.
Civil Judge Junior Division,
Bozali.
Bozali, PAJL. in NSJ case number 15 of 2021, in TS 17 of 2021, thereby rejecting the prayer for rejecting the prayer for amendment of the plaintiff insofar as prayer portion is concerned. Which was which comma according to the Honorable Counsel for the petitioners was necessitated after amendment of the plaint by insertion of two properties described in schedule H and I of the plaint, of the amended plaint. So now, order to be HNI, order to be inserted in the plaint by way of an amendment, which was also allowed by order dated 31/8/2023. Next. Issue notice. Returnable in 4 weeks. Because of extra copies of the of this revision, the petitioner shall take steps within 2 days for service of notice on the respondents by registered post with registered post with AD. In addition, the petitioner shall also take steps by usual process for service of notice on the respondents. Next, in addition, the petitioners are directed to file a copy of this order by way of a petition before the learned trial court and serve copies thereof to the learned counsel for the respondents. Next paragraph. Till the next returnable date, comma, the further proceedings of title suit number 17 of 2021 pending before the Court of Learned Civil Judge, Junior Division, Bajali, shall remain stayed.
Delhi 7 to 9. Stay vacating.
Yes.
It is a Lordship. Lordship, my learned senior has filed the IA civil number 1488 of 2022, Your Lordship, for vacation of the interim order, Your Lordship, which is dated 9/9/2022.
That is your petition.
That is our petition. We are the writ petitioners, Your Lordship. My learned senior appears for respond number 8.
Yes.
Yes. Your Lordship will take up the writ petition first, Your Lordship.
I think on the last occasion, since the even for the purpose of IA, the same length of argument will be necessary. Therefore, on the last occasion, actually, Lordship took up the main writ petition and heard it for some length.
Yes. Lordship had noted a couple of dates also.
Just one.
Yes.
So, Barbara, you are for the petitioner.
I'm for the private response.
Okay.
Respond number 8.
Who is the petitioner?
I'm for the petition.
Okay.
Yes.
And where is this IA filed for?
Yes, this IA, your lordship, has been filed for vacation of the stay, your lordship, which was granted by this honorable court on 9/9/2022. The stay which was granted is, lordship, that by the impugned order, we were demoted to the lower garden. The stay which was granted is that pending final adjudication of the matter, those three vacant posts, your lordship, shall not be filled up by the feeder garden. That is the stay which was operating, your lordship. My learned senior friend, your lordship, has filed the IA to vacate that stay, your lordship. They belong to the immediate lower garden, your lordship.
IA is filed by Mr. Barbara.
Yes, yes.
Oh, so now I understand. Because
Yeah,
I started
actually,
feeling
yes.
a confusion.
No, we have not filed the IA.
Actually,
Uh-huh.
my lord, we filed the IA to expedite that matter because keeping 4 posts not to be filled up, that serves nobody's purpose actually, and it is not also in the
Now
public.
get it. No, I was thinking that he is the lead petitioner. He has filed a stay application, vacating application. It was not registering in my mind. I was under the impression that he is the applicant for vacating and he
No,
is the
no,
petitioner.
it was me,
Okay.
my lord.
Okay.
I'm enjoying the stay. your
Okay.
lordship.
Yes. 5902 we were hearing.
5902, your lordship, is the.
On the last occasion, you were referring to this
Two dates.
reply at page 28.
Yes.
And then you were saying that the petitioner was promoted and upgraded on 23/9/2013.
Yes.
Then the
Then it was.
then the regulation was not there,
Yes.
and therefore higher qualification cannot be applied.
Yes.
You are referring to regulation of 24/2014.
Yes.
Yes.
Yes. If I may be permitted to take your lordship again through those annexures, your lordship, the primary contention of the petition is, your lordship, in this writ petition is that the regulations which stipulate an MSc degree qualification for the post of an environmental scientist shall not be applicable on the petitioners because the petitioners' rights have accrued prior in time on 23/9/2013, which was made absolute on 12/8/2014, although after the regulations came into place, but the benefits which are granted to the petitioners as environmental scientists had flown back from 23/9/2013, your lordship, as has been stated, your lordship, at page 24. Page 24, if your lordship kindly comes to for a moment. The first paragraph. Page 24, your lordship. Page 24.
24, you said that benefit of promotion was from the date of joining.
No, it is from the date of 23/9/2013. Your lordship sees the first paragraph, your lordship, at page 24, Annexure D.
Yes.
In pursuance to the decision taken 96 board meeting under agenda item number so and so, 4 posts of assistant environmental scientist are upgraded to the level of environmental scientist, and the following 4 senior most assistant environmental scientists are allowed to hold the upgraded post of environmental scientist with effect from the date of their joining as shown against their names. The pay and other promotional benefit will accrue to them with effect the date of their joining as per the board's order number dated 23/9/2013. 23/9/2013, your lordship, is not a random date. 23/9/2013 was the date when the respondents along with the petitioners were upgraded to the post of an environmental scientist pending a final confirmation from the board. That final confirmation, your lordship, that took place in the month of August 2014. Now, August 2014, your lordship, is although after the date when the regulations came into place, but this order, your lordship, cannot be viewed in isolation. This order has to be viewed and connected with the earlier order, which granted the benefit of environmental scientists to the petitioners from 23/9/2013 when the regulations are not in place. Now,
You can't be given effect from 23/9/2013.
yes,
You can't be given effect from that anterior date of 23/9/2013.
yes,
You see, because this order says from the date of joining,
yes,
there are 2 classes of service where it is from the date one assumes charge of office,
yes,
and the second category is this one, which is from the date of joining.
yes,
So you see, like for us,
yes,
on revision, the notification said from the date we assume charge. So the order of notification may be of any date, but it's a date when the person assumes charge of the office.
yes,
From then it becomes effective.
yes.
So therefore, giving an anterior date of 23/9/2013
Yes.
would be contrary to this 12 August 2014 notification. And
In
once
fact,
that regulation comes into force,
Yes,
then you will be bound by that regulation.
yes. The regulations, Your Lordship, subject to Your Lordship's final determination. The regulations, unless it states retrospectivity in specific detail, Your Lordship, it has to be prospective. Our submission on this writ petition is, Your Lordship, that our rights flow from 23/9/2013, as has been laid down by this order dated 12th of August 2014.
No, but
Because-
you show us legally that it is
Yes.
permissible. That is the only argument.
Yes, yeah, that is the only argument. If Your Lordship can kindly for a moment come to page 23, Your Lordship, the earlier page.
23.
23. This order, Your Lordship, is the order which has been referred in the later order, which is 23/9/2013, subject to the approval of the board.
Just a moment.
Yes.
Yes. 23.
Page 23, Your Lordship. Subject to the approval of the board. If I may permit it to read, Your Lordship.
Yes.
This order is dated 23/9/2013, Your Lordship. Subject to the approval of the board, the post of assistant environmental scientist in the board are upgraded to the level of environmental scientist with immediate effect. Consequent to that, the following assistant environmental scientists are upgraded to the level of environmental scientist. The pay and other promotional benefit will accrue to these scientists with retrospective effect only after approval of upgradation by the board. So the rights of the petitioners along with the respondents at that point in time, Your Lordship, arose on 23/9/2013, which is indicated by this order. It says, Your Lordship, that the pay and other promotional benefit will accrue to the scientist with retrospective effect only after approval of upgradation by the board.
the retrospectivity of this order, your lordship, was fulfilled at annexure D at page 24. So
Yes.
reading annexure C and annexure D, your lordship, it is apparently clear that the rights of the petitioner originated on 23/9/2013 as indicated by the earlier order, which is dated 23/9/2013, and the subsequent order of confirmation of the promotion of the of the petitioners.
Okay.
The respondents, your
Just,
lordship.
just,
Yes.
just a moment. Mr.
Yes.
Barua,
Yes.
what is your stand? Did the Pollution Control Board approve the retrospective effect of promotion? Reference to page 23 and 24 of the writ petition.
This is with regard to the original provisional promotion, that 2013.
No, 23, page 23 says.
Yes.
Pay and promotional benefit will accrue to this first, last line of this paragraph. Will accrue to this
Yes,
sentence with
with
respect only after
retrospective
approval.
effect
That means,
only after approval of upgradation by the board.
no, that means retrospective effect.
Yes.
That also has to be approved by the board.
Yes.
Was that done?
In fact, that is board's proceeding of 96 board. 96 board.
So just tell me, because I had lost, what do you call, I had lost the track, so therefore I won't remember.
Yes. In fact,
Ninety-first,
yes,
91st minutes,
96th.
96th. Where is that?
Lordship, if I take your lordship to page 3 of my affidavit.
You have the continuous running number? No. Affidavit by respondent number?
Respondent number 2 and 3.
2 and 3.
Yeah.
Verify one thing, my lord. I'm sorry to interrupt. My lord, lordship, in item number, petition number 5061 of 2021, there is an order passed by your lordship in the earlier round of litigation. That is at page 54. That fellow perhaps will clarify certain things. My lord. Lordship has decided the matter on the different occasion, my lord, but same parties.
No, but what about the retrospectivity? Was that
But what
decision
happened, my
taken?
lord? My lord, I'll just, with reference to page 54, my lord, I'll submit, my lord. The petition, my lord, the Rabiul Haq was the petitioner in the other two writ petitions. He was, by way of an order, he was given retrospective promotion from a date he was not even born in the Qadar. So by this writ petition, the petition number 5055 of 2016, and another writ petition that was put to challenge, which was decided by your lordship. And in fact, my lord, lordship has kindly come to page paragraph 22 at page 64 of the judgment, my lord.
Page?
Page 64, paragraph 22.
Yes.
Lordship has got it, my lord. It is seen from the affidavit in opposition filed by the respondents number 2 to 4. It is made to appear that the selection committee had considered the cases of various officers and had recommended their promotion. Accordingly, on the basis of the recommendations given by the selection committee, the 96th board meeting, 4 posts of AES were upgraded to the level of ES, and 4 senior-most AES, including the petitioner in WPC number so-and-so, were allowed to hold the upgraded post of ES with effect from the date of joining.
From the date of joining. From the date of joining.
Yeah, date of joining was, my lord, immediately after the order. It is, they were working in the same office in the Guwahati only. Date of joining, that was pending council will probably they specify the date. As per my instruction, it may be either on 23rd of September or 24th, my lord, not later than that. And page 34, well, that order of 23rd September.
Let Mr. Barua conclude, then I'll come back to you.
My lord.
Because this retrospective effect, that is the only point.
Activity is clarified in the, my lord, order dated 12 August 2014. Board has already clarified. Prospectivity of the order has been clarified by the board by order dated 12 of August 2014, which was just read. At page 24, at page 24 of the earlier repetition, and in this repetition, page 40.
Okay.
In pursuit, that has been approved by the board.
Melody, their main contention is that they were by page 24 order, in this petition.
No, Mr. Barua, the only intention is to understand the argument.
Yes, my lord.
Because he is not completed.
Let him finish that.
Because it's only for clarification of his statement that I'm asking him. Whether the retrospective effect was approved by the board, that is the only question I'm asking.
My lord, there is a provision in the state. My lord, their entire case is about retrospectivity. Is that by page 24 order, actually they were upgraded to take charge, not promotion. Also, the service regulation came into effect on February 24, 2014, and they joined in September 2013. Now, Lordship, to reply to that, my lord, I take your lordships to Regulation 1 Roman 3. Regulation 1 Roman 3, page 33 of the read petition. This one read petition, my lord. Page 5902, page 33. Has your lordship got it? Page 33. Page 30.
Yes.
Come to my lord. 1 Roman 3. These regulations shall be applicable to all whole-time regular employees of the board, whether appointed on a time scale of pay or on fixed monthly pay or salary, appointed either before or after these regulations come into force. So that means the point about retrospective, whether earlier or subsequent to these regulations, my lord, and this provision has not been challenged by them. Had they challenged it, they would have gone to the division bench. Or maybe a regulation before these bench also, they have not challenged this. Therefore, the question of retrospectivity doesn't come here. It can be applied to. The appointment formula is very simple under the statute. And there cannot be any concession overriding the provisions of the statute. That you are a BSc, all right, we are allowing you to hold charge of the next type of post, but you must obtain your master degree within five years if you fail. They are not out of employment. They are rewarded. Now kindly turn to.
I'll come to you, otherwise I'll be confused. I'll come to you later on. Because otherwise I'll be confused.
So that is retrospective.
So retrospective effect you are not opposing. You are saying that
their argument doesn't hold good, my lord, in view of 1 Roman 3. and they have not challenged it.
Yes, Mr. Barwa.
Yes.
The 96th resolution, does it give that retrospective effect as per page 23?
Yes, sir. Retrospective. So here again, I have to adopt that argument which has been placed by my senior. This is with regard to the regulation which says whether it is the past or present employees, they have to be guided whether so the retrospective or prospective or the present employees, they have to be guided by the regulation which comes into force subsequently. And with regard to that present petitioners, so the present petitioners has been provisionally promoted. Subsequently, subject to the approval of the board, finally the regulation comes into force, and immediately after the regulation comes into the force, the board said over the matter, and they have said that these employees don't fulfill the regulation 9(3)(c). Accordingly, their service needs to be demoted. So this is the crux, the subject matter of the case. So without confusing here and there, so I would like to concentrate only to that particular.
Okay, then we'll come back to you.
Yes.
Mr. Complete. Mr. Sharma,
Yes.
let him complete.
Your Lordship had gone through page 23 and 24, Your Lordship.
Yes.
The basis for the orders at page 22, at 23 and 24 is annexure B at page 22. This is the very admission of the Pollution Control Board, Your Lordship, had gotten page 22, Your Lordship. This is the genesis by which there was a conditional promotion and then there was an absolute promotion.
These were
At page 22,
the posts were redesignated
the posts were redesignated in the last paragraph, Your Lordship would see.
for promotion of chemist with BSc degree.
Yes, exactly. In between the ranks of assistant environmental scientist and assistant executive environmental scientist, the board has approved the post of environmental scientist for direct recruitment of science postgraduate, which is not disputed, as well as for promotion of chemist with BSc degree, which is presently not held by anyone and therefore not shown in the table. This was the requirement of the Pollution Control Board, that a promotee with a BSc degree will suffice to enjoy the post of an environmental scientist. This was a communication of the Pollution Control Board themselves on 7th of April 2012. Much prior. Pursuant to that, the petitioners and the private respondents, Your Lordship, were promoted. Yes, were promoted the post of environmental scientist, although provisionally, Your Lordship, on 23/9/2013, which was reaffirmed on 12th of August 2014. Although the regulations had come into place, the final order of confirmation of approval of promotion, it traces back its roots, Your Lordship, to the communication at page 23 and the communication at page 22, which clearly proves that at that point in time, for a promotee to be promoted to the post of environmental scientist, the BSc degree was sufficient enough. It is not the case of the Pollution Control Board that the petitioners were direct recruitees. It is also not our case that we were recruitees, direct recruitees that would be warranted by the requirements of table 3, which we will not go into now, Your Lordship. Our sole submission in this matter is that our rights originate prior to the regulations coming into force. Our rights originate at a point in time when it was only a promotee with a BSc degree who would be considered for promotion before the regulations come into force. And that is our two-legged argument in this matter. And that we cannot be taken as a part of the regulations stipulating the educational criteria for promotion to the environmental scientist. To the subsequent cadre, Your Lordship, which is assistant executive environmental scientist, I'll obviously be guided by the regulation of 2012. That is not in dispute. What I'm challenging, Your Lordship, at this point in time is my demotion from a rank where my rights had solidified pursuant to the confirmation of my promotion. That is the crux of my argument, Your Lordship. That is the crux of my argument. And I'll be guided by the Pollution Control Board regulation which will subject my promotion to the next higher cadre, but to the cadre where I was already placed and where I was already approved and confirmed prior to the regulations coming into force. The regulations cannot go back in time. And regarding your lordship at page 33, like my learned senior friend has pointed out, that these regulations shall be applicable to all whole-time regular employees of the board, whether appointed on time scale of pay or on fixed monthly pay or salary appointed either before or after these regulations come into force. That is not in dispute. I'm subject to the regulations, but I'm subject to the regulations after appointing time. I cannot be subject to the regulations with my substantial rights being taken away by regulation retrospectively. I'll be guided by the regulations as far as my promotion to the subsequent cadre is in question, which states that there has to be an MSc degree within a few years of me being promoted. I'll be subject to the regulations on that count. But on count of me already having been promoted to a cadre before the regulations came into place, and me tracing my rights back to a point in time when the regulations were not in force, and without the regulations retrospectively stating that my rights cannot be taken away. I've been demoted to a rank after which I was promoted, stating primarily on the basic premise that I had a BSc degree. That page 22 clarifies. Page 22 clarifies that I had a BSc degree, which was enough to entitle me for promotion to the post of environmental scientist. It is the Pollution Control Board's communication. It is not my communication. It is their communication that states that I fulfill the criteria. Then they provisionally promote me. Then, subject to approval, they confirm my promotion. Not from August 2014, but from the month of September 2015. And yes, I'll be subject to regulations, Your Lordship, as far as my promotion, my service benefits are concerned after the regulations are coming to place. Not after my rights have solidified in a cadre. And I've served there, Your Lordship, for 8 odd years before I was taken into. That is the crux of our submission.
This impugned order is page 40.
Your Lordship, the impugned order is at page 40, Your Lordship. Page 40. Your Lordship, the first order is in regard to the petition number 1. In the interest of public as well as board service, and as per the recommendations of the board, as per agenda number so and so of the 104th board meeting held on so and so, and also considering the view of standing council submitted by letter dated so and so, the petition number 1 is reverted back to the rank of assistant environmental scientist with immediate effect. The second order, Your Lordship, it's with regard to petition number 2.
Okay.
And the fourth order is with regard to petition number 3, Your Lordship.
Yes.
That is the crux of
That is the only point.
I have a few case laws to cite. I can cite that in reply if Your Lordship permits.
You can cite it.
Yes, yes. Yes. Lordship, citation 1, 1997, 6 SCC, Your Lordship, page 623. 1997, 6 SCC, page 623. Your Lordship would kindly come to paragraph number 20, Your Lordship. If I may permit it to read, Your Lordship, a small paragraph.
Just one.
Yes, yes.
1997, 6 SCC, 623.
623.
3.
Paragraph number 20, Your Lordship.
It would be.
Paragraph 20. If I may read. It can therefore be said that a rule which operates in futuro so as to govern future rights of those already in service cannot be assailed on the ground of retroactivity as being violative of Article 14 and 16 of the Constitution, but a rule which seeks to reverse from an anterior date a benefit which has been granted or availed, example, promotion or pay scale, can be assailed as being violative of Article 14 and 16 of the Constitution to the extent it operates retrospectively. Paragraph 24. In many of these decisions, the expressions vested rights or accrued rights have been used while striking down the impugned provisions which had been given retrospective operation so as to have an adverse effect in the matter of promotion, seniority, substantive appointment, etc. of the employees. The said expressions have been used in the context of a right flowing under the relevant rule which was sought to be altered with effect from an anterior date and thereby taking away the benefits available under the rule in force at that time. It has been held that such an amendment having retrospective operation which has the effect of taking away a benefit already available to the employee under the existing rule is arbitrary, discriminatory, and violative of the rights guaranteed under Articles 14 and 16 of the Constitution. Thereafter, Your Lordship, there is another citation. The citation, Your Lordship, is 2007, 6 SCC 220. Paragraph 19, Your Lordship. It's a summation of the observation in the matter. In this case, we are not concerned with enforcement of the rules. They were brought in force at a later stage. Paragraph 9. If I can read, Your Lordship. Yes. In this case, we are not concerned with the enforcement of the rules. They were brought in force at a later stage. It is for the state to apply the provisions of the state rules only if an occasion arises. Therefore, but keeping in view the fact that the state rules have not been given a retrospective effect, the impugned orders.
6 SCC or 7 SCC? 7 SCC.
6 SCC.
6 SCC. Oh. Oh, actually 6. Okay. Okay. Because you said 7, I don't notice 7.
I apologize. I apologize so much.
Okay. Okay. Yes.
There's one more citation, if Your Lordship permits me. Just, on the same lines, Your Lordship.
Here, which are the paragraphs in 7, 6 SCC?
Only paragraph 19, Your Lordship. Only 19. It's a small paragraph, Your Lordship. It captures the ratio, Your Lordship, that in this case, we are not concerned with enforcement of the rules. They were brought in force at a later stage. It is for the state to apply the provisions of the state rules only if an occasion arises, therefore. But keeping in view the fact that the state rules have not been given a retrospective effect, the impugned orders cannot be supported by reason thereof or otherwise. The language here, Your Lordship, that says that it is for the state to apply the provisions of the state rule, that can be attributed to definition 1.3 that my learned senior pointed out, that I am subject to the rules, Your Lordship, subject to any action that might be taken with respect to my service. at a later point in time. My subsequent promotion is subject to the regulations, and that cannot be disputed by me at any point in time, Your Lordship. What I'm claiming in this writ petition is that the right that accrued to me as an environmental scientist, the right which had accrued to me by dint of me being a BSc graduate as a promotee, that those rights have solidified. Yes, yes, yes. Yes. Your Lordship, then there's the last citation, Your Lordship, 1994, 4 SC, page 602, Your Lordship. 4 SC, 602. Right, 26. If I may permit to read, Your Lordship. The designated court has held that the amendment would operate retrospectively and would apply to the pending cases in which investigation was not complete on the date on which the amendment act came into force, and the challan had not till then been filed in the court. From the law settled by this court in various cases, the illustrative, though not exhaustive, principles which emerge with regard to the ambit and scope of an amending act and its retrospective operation may be culled out as follows. A statute which affects substantive rights is presumed to be prospective in operation unless made retrospective.
22. That's 22.
26.
26. Oh.
26. There's some. There's certain points have been given here. If I may permit to read it, point number 1, 26.1. A statute which affects substantive rights is presumed to be prospective in operation unless made retrospective, either expressly or by necessary intendment. Whereas a statute which merely affects procedure, unless a construction is actually impossible, is presumed to be retrospective in its application, should not be given an extended intended meaning and should be strictly confined to its clearly defined limits. Your Lordship would kindly come to the last sub-point, Your Lordship, sub-point number 5. A statute which not only changes the procedure, but also creates new rights and liabilities shall be construed to be prospective in operation unless otherwise provided, either expressly or by necessary implication. That is my submission.
Yes. So, Barbara, we'll hear you. I'll take a break and come back.
Yeah.
But if your Lordship holds that yes, these are also promotion, then it is always conditional that they have to obtain master degree within 5 years. This is a requirement, statutory requirements. This is a requirement, statutory requirement. And petitioner falling under applies to them. It is a primary condition precedent, my lord, and there is no getaway from this provision, qualification. Now, my lord, kindly come to and hence their revision. They failed to obtain master's degree, hence their revision. In fact, notices time and again, page 25, the appointing authorities, first they gave it in 2016 itself. To all 6 of them were in fact appointed out of 7. One didn't come for before this court, one came here, but during pendency retired. 6 or 5. Anyway, that doesn't matter. But by the notice, six, yes, 1 retired. Qualification required as per Pollution Control Board Assam service regulation. Pollution Control Board Assam employees regulation by requirement 9A and C, which I read. fixed qualification, experience, promotion. As per above mentioned, my lord, it is provision is quoted that within 5 years of the service, you are to obtain your master degree. And therefore, we have, on that condition, we have allowed you to join. All of you are BSc degree holders. Please let this board know whether you have applied permission to the board for pursuing postgraduate degree at any recognized university or not. This was not replied to by them. They gave certain, this was not replied to.
There is page.
Page 26, 25. I am reading page 25. Page 25. So here in the last sentence, they reminded them, well, we allowed you to join on the condition that you obtain master's degree. So have you applied to any university or taken any steps to obtain from any recognized university? And they were given 15 days time. This was dated 12 September 2016. It was not replied to by the petitioners. So the authorities were from time to time reminding them that, well, you were given conditional joining. Have you obtained MSc? Then, my lord, the next page, page 26. Another one. Qualified. As you have failed to furnish reply against the office order under reference within stipulated, it is presumed that you have failed to comply with the provision of Pollution Control Board. In view of above, please note that the board will initiate appropriate action in due course of time. And then, my lord, ultimately, it was 16. From 16 to 21, they didn't do anything. After 5 years, it was in 2021, in between, from March 20, there were the pandemics. They gave this another representation. And, my lord, it was a show cause given by them, my lord. Enough is enough. 5 years have gone past. You have not obtained your master's degree. As per records, you have not acquired postgraduate. Therefore, you are hereby directed to reply within 7 days. At least one final natural justice was given. Or else appropriate action will, why shouldn't be initiated against you by the board for non-compliance. Then to this, they gave a reply. It's a long reply. It is virtually what they have stated in the writ petition. At page 28. That the board post facto approved, they are joining. That there is no retrospective provision and all these things. That they were under bona fide belief that the matter have been settled and all this. Then, my lord, page. And then, as I have said, my lord, page 33, there was a provision that these regulations shall be applicable to the whole-time regular employees of the board, whether appointed on a time scale pay, monthly salary, either before or after these regulations comes into force. So this provision, what I submitted, my lord, initially, has no have been challenged by them. So authorities are empowered. And retrospectivity or otherwise also, no vested right basically accrued to them. And hence their reversion by the impugn order. The authorities have time and again reminded them, insisted upon. So they have not completed, my lord. I am the lady next above, my lord. So keeping the post not to be filled up, I joined as a master degree holder at Eastern Environment, right from day one. So that is my conflict of interest. And by this order of reversion, they are not put out of employment. They were reverted. And rightly, I submit. Rightly, under the statute, giving sufficient natural justice, since they were not eligible and qualified under the statute, no substantive or vested right, they can claim. That's all, my lord.
Yes, yes. Yes, Mr. Barwa, you have anything more to say?
Yes. Already majority of my argument has been taken care of by my senior, but still then I would like to add up some 3 points. This is initially I have to go from that the date of the upgradation of promotion, provisional upgradation of the petitioners, that is on 23/9/2013.
But your statement was interesting. You don't adopt his argument, but he took care of your argument.
I have reduced his burden.
He has reviewed major part of my burden, in fact. So the initial upgradation of provisional upgradation was done on 23/9/2013. So Lordship is aware about it. That point of time, are these employees who have been upgraded, they are guided by any guidelines, regulations, or draft regulations. And to substantiate my argument, I have to go back to the draft regulation that has been adopted by the 94th board. The 94th board, prior to the 94th board adaptation of the draft regulation, there was no such regulation in the board. We were guided by the Water Act and the Air Act. So these regulations are the regulations which has come and streamlined the service discipline of the employees of the Pollution Control Board. So this draft regulation has been approved by the 94th board, and this 94th board has sat over this matter. And finally, these upgradations has to be approved. Yes. So this 94th board meeting, the relevant portion of the 94th board meeting, even though in this particular petition I don't have it, but I have to just land it from the other petition which are connected with it. So still then, I would like to just brief up here, let's say, only with regard to WPC 8263 of 2022. 8260 of 22, there running page 127. One, two, three. Ajol also.
Yes.
Yes, 127. This is the relevant portion of the 94th board meeting held on 23/2013. So 23/2013. This is immediately prior to those upgradations. So if I'll also take you all to subparagraph 3 of this resolution. The board also decided that all the employees holding an existing post in any cadre of the board service and their name appears in payroll of March 2013 shall be treated as a regular employee of the board under the adopted regulation. Then comes the phrase recruitments / promotions in the board shall have to be made as per the new regulation now onwards. So this is the new regulation. The draft regulation is the new regulation. Guided by it. Okay. So now, after this upgradation is subject to board's approval, everything has been done. Subsequently, the Pollution Control Board Service Regulation has been approved. So this has come into force from 24/2/2014. 24/2/2014. These date has to be calculated because they are disputing that they are not guided by the present regulation. And they are totally silent whether they were guided by the draft regulation which comes into force from 23/2013. So they want to point out, make a clear picture before the court that they are not guided by the present regulation because the retrospective effect has come into force.
What is the date of draft regulation?
The draft regulation has been approved by the 94th board on 23/2013. 23. And it is very clear that this draft regulation will be the regulation that will be guiding the employee service from here onwards. Draft is not a draft. That point of time, you would not have been getting in salary.
Yes.
So then then the 94th board meeting set over the matter because 2013 they have been upgraded subject to the condition that they have to be guided by the regulation 93C, which says that either they have to complete 10 years of service, or if at all they are MSc, they have to complete BSc. So they have to complete the MSc qualification within 5 years thereafter. But since they were on the verge of completing the 5 years term period, which has been set forth by the draft regulation, so didn't complete. Accordingly, the board set over the matter. They have been so-called several times, and they have been questioned whether they have applied for board's permission to seek MSc degree. They never applied. Subsequently, so-cause has been issued why stringent actions should not be taken because of violation. They didn't reply. Thereafter, another so-cause has been issued. So in response to that, they have replied to the fact that they never said that we are not guided by the draft regulation, we are not guided by this regulation. They only said that we need a relaxation of the provision of 93C. So they very well knew about the provisions which were existing at the time when they have been up.
the petitioner could not have filed this writ petition with a similar prayer, my lord. Had it been a case that it was withdrawn with liberty, it would have been a different proposition, my lord.
Yes.
The first objection is that it is not maintainable in view of the withdrawal. Any promotion which has been given has attained its finality. He put to challenge that order. Subsequently, he preferred to withdraw without any liberty. Now, my lord, the subsequent writ petition challenging a promotion order in the year 2021, challenge the promotion order which was given in the year 2014 itself, my lord. That laches is also there, delay and laches on the part of the petitioner, my lord. Second ground, my lord, the petitioner is holding the post of AES, Assistant Executive Environmental Scientist. And the next promotional post is Environmental Scientist. From Environmental Scientist, the further promotion is to the AEES. The person who is holding a post of Assistant Environmental Scientist does not have any locus to challenge an order of promotion to the post which is much higher than that of the petitioner holding the post, my lord. Petitioner admittedly is holding the post of AES.
Petitioner is
Rabiul Haq, my lord.
Yes,
he is Assistant Environmental Scientist. And he is Assistant Environmental Scientist. Lordship has already gone for these regulations. The promotional post of AES is ES, that is Environmental Scientist. And from ES to Assistant Executive Environmental Scientist.
from environmental scientist to
AEES, that is Assistant Executive Environmental Scientist.
yes.
Well, of the respondents, 3 and 5, I'm appearing for 3 and 5. They are holding the post of AEES at that point of time. So the petitioner does not even have the locus to challenge the promotion order because he will not get promotion to the post. But his prayer is to promote him directly. But in the meantime, while challenging other person who are junior, their seniority would be altered, my lord, if the petitioner is directly promoted from AES to AEES. And all those persons whose seniority would be disturbed if this writ petition is allowed are not made parties here, my lord. There are other persons as well, apart from these respondents, my lord. Those who are already holding the post of ES as well as AES. That is, my lord, in the affidavit I have clearly stated. And one is, my lord, misjoinder of distinct and separate cause of action. This is also not maintainable. All these private respondents were given promotion on different dates. He has, by filing a common writ petition, all these cause of action could not have been clubbed into a single writ petition, my lord, because date of promotion of each and every respondent is different. Maybe in 2-3 cases they may be same, but in respect of 3, 4, and 5, date is different. 6, 7, 8, 9, date is different, my lord. And all this has been clubbed in a single writ petition, my lord. So this is misjoinder of cause of action. On this count also, my lord.
Not in a writ petition.
My lord.
Not in a writ petition. That will not be fatal.
Well, my submission, that is my submission, but just say separate causes of action. Had it been a common order, same date, same writ petition, it would have been different. But since different dates, every respondents were promoted on different dates. Basically, my lord, he had already withdrawn the writ petition. His challenge made was withdrawn by the.
That point we have taken.
Yes. And regarding, my lord, that is in respect of this writ petition, my lord. And in respect of WPC number 8263,
private respondents were further promoted to the post of executive environmental scientist from assistant executive environmental scientist.
Respondents were promoted to the post of
Executive environmental scientist.
so
Further promotion was
further
given.
promotion.
Further
Okay.
promotion was given. The petitioner, who is holding the post of assistant environmental scientist, has challenged that promotional order, my lord, order of promotion. Here also, I have raised the objection regarding raising maintainability of the writ petition on the ground of locus standi of the petitioner, my lord.
What is the full form? Just tell that from AES to
AEES, meaning by assistant executive environmental scientist,
to
to
executive.
the post of executive environmental scientist.
Yes.
Both these writ petitions, minus 5061 and 8263, these are basically issuance of writ in the nature of certiorari and mandamus. This is not a writ of quo warranto that any person having some interest in the subject matter could have filed. This is a certiorari they are praying for setting aside. In order to get that order, there has to be some right in favor of the petitioner seeking that right, my lord. An assistant environmental scientist whose promotional post is environmental scientist could not have challenged the order of promotion whereby the respondents were promoted to the post of, my lord, executive environmental scientist. That is one, my lord. Secondly, he also paid for his consideration to the promotion. By doing so, he has also not impeded all the persons who were holding that post of environmental scientist and assistant executive environmental scientist. If these writ petitions are allowed, all the settled position will become unsettled, my lord.
Yes.
So therefore, my lord, both these writ petitions in WPC number 5061 and this writ, the petitioner does not have any locus, my lord. And one more aspect, my lordship, I'd like to place before your lordship, that writ petition is also barred by constructive res judicata, my lord. Lordship may kindly turn to page, my lord. If your lordship is, lordship, I'll trouble your lordship to go to WPC number 5061 for a moment, my lord. Lordship will come to page 54. Hiten Sharma and Manoj Borua, who is the petitioner in item number, respondents in the other matters, my lord, and Manoj Borua is the petitioner in item number 7 as well, my lord. They challenge the promotion order. The lordship may turn to page 57. This judgment was passed by your lordship, my lord.
Yes.
Lordship, what was impugned in the writ petition, my lord? Lordship, page 57, paragraph 3. By the two writ petitions filed under Article 226 of the Constitution of India, the petitioners have challenged the impugned order number so and so dated 24/6/2016, by which the respondent number 5, that is Rabiul Haq was respondent number 5, my lord, was given promotion and making him senior to the petitioners, and consequently the petitioners have prayed for restoration of their seniority over respondent number 5. As the two petitions assails the same impugned order, the facts narrated so and so. So what happened, my lord? By way of this order, 24/6/2016,
Yes.
chairman of the board of its own, in violation of the decision of the board, granted the retrospective promotion to the person, the petitioner in the present case, from a date he was not even born in the cadre. He was given promotion from AES to ES with effect from 30/7/2013. And from ES to AEES with effect from 1/1/2014.
Yes.
Now, lordship may recall, by order dated 12th of August 2014, when 4 persons were approved, board rejected the upgradation of Rabiul Haq, my lord. Page 40 for a moment, my lord. Lordship may, if you lordship turns.
Yes, this is
Yes. Rabiul Haq, he was from that initially by 23rd of September, 7 persons were upgraded. On 12th of August 2014, board approved only 4 names, and these remaining 3 were reverted back to the post of AES. At that order of the board, the petitioner, the Rabiul Haq, never challenged this order of reversion. And without that, by this order, by the 24/6/2016, chairman of its own granted retrospective promotion to Rabiul Haq from AES to ES with effect from 30/7/2013, and from ES to AEES with effect from 1/1/2014. Whereby Rabiul Haq was made senior to that of Riten Sharma and Manoj Borwa, who were otherwise senior in all aspects, from date of birth, date of joining in service, date of joining in the respective cadre. In all aspects, they were senior, my lord. This order, the lordship finally interfered with this order, my lord. I'm not going to trouble your lordship to read the entire, my lord. Lordship, I'll take you to the operative portion, my lord.
Then I have noted.
Right.
He was reverted back. He was not born with the
That
cadre.
seniority was restored. Against this order, Rabiul Haq has preferred a writ appeal, which is pending. So, if the appeal is allowed in his favor, whatever prayer is made in this writ petition will be covered. So, therefore, all these 2 writ petitions are also barred by constructive res judicata in my respectful submission, my lord. Since appeal is fixed at the hearing stage, if the writ appeal is allowed, the petitioner will not have any grievance, my lord. His seniority will be restored. He will get his seniority, what was impugned in these writ petitions, my lord. In that sense, my lord, this writ petition is also barred by constructive res judicata. And the order of 2014, my lord, would not have challenged in the year 2021, my lord, because persons were promoted in the year 2013, 2014 to ES and AEES. In challenging that order, because why he has to challenge, my lord? One way he is filing appeal against the order, and on the other hand, he is also filing writ petition, praying similarly. If your writ petition is allowed, that all his prayers will be taken care of, my lord. That is my submission, my lord. And since board has already on affidavit stated that it is a retrospective, not retrospective, only prospective in nature.
Already taken note.
Yes. The other part, my lord, lordship may not like to even go into.
Yes.
All these restrictions are mainly particular provision regulation 9 PCM, which requires for a course promoted or direct to the post of environmental scientist. A candidate must have to be master degree in environmental science or everything. There is none of the respondents have that qualification. And so far, the 5 years is they are saying that water partner in 2049 challenging in 2019 or 2020. They were given 5 years. As far the lordship has already gone through the regulation. In this regulation, another aspect is there. Kindly come to this regulation.
No, without addressing the maintainability, why should we hear the view on merit? If you have already made that prayer, which is pending before the
Division.
you have challenged the order of this court in the division bench.
This is a subsequent cause of action. Why I am saying that they were promoted to the Asian environmental scientist. They are Asian executive environmental scientist. Thereafter, they are other promoted to executive environmental scientist. To that, according to the qualification of MCD. And the petitioner is WPC number 5061 and 8263. He is the only MNC qualification. And the landed council for the respondent number, they are saying that I have not been born in the Qatar matter. You could rush go through the promotion order. Except say that they are promoted.
No, you see, this argument before this this bench would be something like what is called addressing someone who can't hear. You see, after this bench has set aside the order of your promotion from the post of AES to ES and then from ES to AES, making the same argument before this bench should not take you anywhere.
That part is over. That is
No, you see, but the argument of Mr. Chakravarti makes sense. If your writ appeal is allowed, what will be the consequence? Your position as AES will be restored. How can a writ petition be maintainable?
These petitions, they are under qualified person. They are given promotion even after one to another.
We give you a choice. You are pressing for this relief in this, or you will be pursuing your remedy in the appellate court. You take a call, you take a choice, considered choice. Because you see, this is a question which I'll pose in my order. That this is a question which was put to you, and this is a choice you have taken. You sit down, think over for 2 minutes. We'll again address you. The question is that why, because if I am hearing you, then I'll pose this question in the order. that you are given a choice. It may have consequences in this writ petition, it may have consequences in the writ appeal. Sit down, think over. We give you time for 2 minutes. Sit down and think over. If you're ready, you can address, but if you're not ready, you can take 2 minutes time and think over. No, after hearing it, we won't segregate. It would be the same. It would be the same. Because you see, question of maintainability was raised. So issue of maintainability has to be addressed first. There's no escape. No, maintainability, having heard it, we are not adjourning it. I'm not spending time for fun. We have started hearing at about 12 or 11 o'clock. Okay, I'll take up other matters in the meanwhile.
Item number 2. This is a case of landlord tenant matter. I am the tenant. Judgment of reversal. On 2 grounds, suit was filed. Defaulter and bona fide. The trial court on both the count held that there was no
Your only case is that this it was there was a balance of 56,000 rupees with the landlord, and therefore you are not a defaulter.
So far defaulter part is concerned. Apart from that, the learned lower appellate court held that there was no section 5(4) has not been complied with before depositing in the court. That was also not in conformity with the record. And so far bona fide requirement is concerned,
the landlord has other rooms which has been let out to others. But that is no choice.
Not choice, but whether their bona fide has been shown to have been proved or not, that is the main question. Because in the initially when the suit was filed, prior to that they have issued one legal notice. In the legal notice, they have taken only ground of bona fide requirement. Regarding defaulter part, they have not taken.
But in Assam, the requirement of 106
not applicable.
is not applicable.
Not applicable. Not applicable. Even then, stand in the notice was that the payment of rent, they are terminated the contract from August. So they are the language was that they have terminated the contract.
And on the ground of bona fide, they want to start, set up a new business there. So they are, we are liable to be vacated. Now kindly see the plaint, my lord, at page 11. For the purpose of bona fide requirement, there must be requirement of genuine need and
If I remember correctly, there was, in this case, 2 or 3 pleas were taken. Number one, that there was the landlord holds a trade license. And then it is projected that the house is in the commercial area and he has got no other house. That is the plea taken, I believe.
In the plea.
If I remember correctly. No, wherever I don't know, I won't remember so thoroughly. I have not memorized. By and large, somewhere I have seen that that is a ground taken. There I will not be able to recollect.
Page 13, paragraph 16.
No, wherever be, I am not.
That besides letting out the tenanted premises to the defendant, plaintiff has also let out the remaining 3 rooms to the aforesaid Assam type house to 3 other tenants on month-to-month basis. Sri Ram Bahadur Mahato at the rate of rupees so and so, respectively. And as such, plaintiff was receiving rupees so and so per month as total rent from all 4 rooms, including the tenanted premises comprising in the Assam type house. That, however, the aforesaid sum of rupees 3,600 per month was not sufficient. This was one of the ground. Not sufficient for the plaintiff to manage the livelihood of her family, consisting herself and her unmarried daughter and son, namely so and so and so and so. As a result of such insufficiency of income, the plaintiff was facing great hardship. It is pertinent to state here that the eldest daughter of the plaintiff, namely so and so, got married in the year 2000, and in that connection, the plaintiff had to bear severe hardship and inconvenience towards arranging the expenditure and cost of marriage. Owing to such hardship, the aforesaid plaintiff in the month of June 2006 decided to start a new business. This is the only statement. Decided to start the business of stationery come gift item at Guwahati, and in that connection, the plaintiff took all necessary steps for starting the said business and has also obtained necessary permission from GMC on 18/8/2006 for running the said business under the name and style Messrs. Dipti Nair. It is pertinent to state that the plaintiff has arranged the requisite money to start the said business of taking loan from her relatives. Except the aforesaid Assam type house, including the tenanted premises, plaintiff has no other alternative premises situated at any commercial locality within the city of Guwahati for running the aforesaid business of stationery come gift items. It is pertinent to state that aforesaid Schedule A property is located at the suitable commercial place besides BGGS Road within the city of Guwahati. That eventually the plaintiff, through her lawyer, so and so, sent to a defendant a notice dated so and so, stating therein the aforesaid fact and circumstances in brief, and further claimed that she genuinely and honestly needs and requires the aforesaid Assam type house, including the tenanted premises for using. It is a showroom for running the business of stationery come gift item. By the said notice, the tenancy was terminated with effect from 31st August 2006. The said notice dated so and so was sent by registered lady. It is pertinent to state here that plaintiff also sent similar notice to her other aforesaid 3 tenanteds. She issued notice to all tenants, not only me. The aforesaid notice dated 11/8/2006 was received by the defendant, who replied to the same through his lawyer, Sri so-and-so, dated so-and-so, whereby the defendant denied the contents of the said notice dated so-and-so and chose to remain in occupation of the tenanted premises. The defendant has not
You see,
vacated the tenant.
sorry to disturb you, but you see, Mr. Ghosh, the ground on which the bona fide requirement was rejected by the trial court is that the landlord had obtained a trade license, and therefore there is a presumption that she was carrying out business. Number one. Second is that the landlady did not have the experience of doing business, and therefore bona fide was rejected.
She
Now
was
let me tell you,
she
when I
was
let me tell you,
housewife.
it's okay.
And
That's what I'm telling you. You just have patience for 1 minute more. You see, when I joined as a lawyer, I had no experience as a lawyer. If somebody had an experience, I don't know.
Now the lady is about 70 years.
When I joined, he may be.
Her son is a builder. He is not doing any business, all these things.
No, he may be a builder or something. But if you see, don't you know any person who is a senior citizen of 80 and doing business? Because if you work with me in a particular road, I'll show you people who are working. There are lawyers who are absolutely active till one of them I know is 94. He's India's one of the topmost lawyers. He expired 2 years back. Ripe age of 94. Pushpan Singh was writing up to the age of 91 or 90.
My lord, one judgment I will show that not only by way of pleading, it cannot be proved that he has the bona fide requirement, he or she, but the essential idea basic to all such cases is that the need of the landlord should be genuine and honest, convinced in good faith.
Correct.
So that
You
must
see,
evidence
no.
she
You see,
will have to
where is the
reduce.
presumption, Mr. Ghosh? Where is the presumption that since the son is doing good, well established in life, the mother will not do anything and stay at home?
And it is not only
Because
that
it would compel. Supposing I have a relative who is a senior citizen, he is ready and willing to work, and I'll tell him that no, I am well settled in the life and therefore don't work. Can I do it? A fundamental right can be violated. It can't be. If a person 70 years says I'll do business, you see, let me tell you, ask you a simple question. Today morning before coming to court, I purchased Tata Salt. There was a requirement at my home, so therefore before coming to court, I purchased Tata Salt. But now no one in the Tata family was selling me that salt. I asked whether the chairman of the Tata Group is there. He said, no, I am selling it. So the chairman of the Tata Group doesn't come to Guwahati to sell Tata Salt to me. So people can work with helping hands.
My lord, this document, before this trade license, they have issued the notice. They want to start up the business. Now, whether on the basis of that document, it can be presumed that they start up the business over these premises, and it is on record. Only for the purpose of filing of the suit, they obtain this type of license. There is no mention that where this shop is to be established. Nothing. That is why I am saying that genuine need, whether it is
You show me the GMC. We give you the GMC Act, Municipal Corporation Act. It says to do a business, one must have a trade license. It doesn't get a teething period that you will start a business and then obtain a trade license.
No, my
I think it's a
my
non-obstante
submission
clause.
is not
No,
there.
no, not that. You see, we must understand things in the context of the law. If this GMC Act permits one to do business and obtain trade license later, then we'll accept your argument. You see, 2 or 3 things we don't have any answer. We'll have to go by our experience. Now, for example, I can tell you within the walking distance of this court, there are shops who have established and doing business without a capital invested. They will just have a shop at a good place, and there will be people who are coming and filling up their shops with goods. They sell it and then make payment. I can tell you so because I come from that community who does business, where money is not very essential. You don't have to be rich to start a business. People with no capital can be doing very good business. It's a, what you call, capital resting in the mouth. If I give a word, they know I will keep it. So we have no real legal answers to something. Many things we don't have. I cannot cite you a judgment and say that, well, one has to have a X amount of cash to start a stationery business. The condition I am not aware, subject to how you convince me.
No, I am not on that. I am saying that only for the purpose of filing of this suit, they obtain the trade license.
How is that
So as
presumption
to-
can be taken? How that presumption can be taken? You see, presumptions are based on the Evidence Act. How we can presume that she obtained a trade license only to evict you? You see, Mr. Ghosh, X is a student. He passes out his what you call LLB, goes to the Bar Council of Assam, gets a registration, and he leaves it and starts a pan shop. On PAWN, not pan. PAWN, that's a respectable business. He starts a pawn shop. Now, now please tell me whether the act of procuring a license from the Bar Council itself is illegal. Is somebody compelled just because he has a license, he will have to do that? Because incidentally, I know a doctor who has his MBBS license, and he is one of the India's largest producer of a particular drug. He has an MBBS license. He left practice in 1965 when I was born. So therefore, you see, having a license is not a precondition that one would do it. And having a license is not also a precondition that one will become a lawyer.
Not, then the evidence of the PW1, whether then any such element.
No, she says that in the cross-examination, she says, if I remember correctly, she says that I don't have experience. That's what I said. When I joined profession, I had no experience. When I became a judge, I had no experience. I did not go to class to take to any school to learn how to write judgments. I had no experience, absolutely no experience. I may have done some mistakes somewhere, but I had no prior experience. I'm not giving a third-party example. I'm giving my own example. Many people were apprehensive whether I would be able to perform. And it's a genuine concern. Some people we know become judicial officers. We thought that, can he do it? He's a good officer. So even when I joined, somebody had apprehensions that this gentleman going there, will able to do it. Somebody starts, when I started lawyering, people were laughing at me. That, how come I came into the profession with absolutely no background. So therefore, you see that evidence has to be tested in parameters of the ability of the person to do it. And ability is not only the person himself. He can have helping hand and do the business. I can't do everything, so therefore I have a court master. I can't do everything, therefore I have a secretary. Without the assistance of this, I won't be able to perform. If you say that, okay, well, you have to write a judgment, do everything yourself. I'll not be able to do. Yes, I'm not questioning you. You see, I am putting myself into that position and then I'm asking questions. If I am there, can I perform without the assistance of the staff I am having, without the assistance I am having of everybody? Can I do a judging without the lawyers addressing me? I can't. So therefore, why cannot a 70-year-old lady start a business?
Now,
There is the only question
at
I'm
that
asking.
point of time, she was not 70. Now.
No,
yes,
70.
now, so At
But
that
70,
point of
why
time,
it
she was
cannot?
not 70. And regarding starting up a business, not
I'll tell
only-
you, I'm conscious that the proceedings are transmitted live, but still I'm telling you, I know a person who's perhaps now about 85, has a huge business, employs more than about 200 people. I have never seen him working. And at 5 o'clock, if you ask him what has happened, he can tell you everything which has happened in his trade. If you go to his place, he will speak to you just like a child. If an elderly people goes to him, he will speak like an elderly people. I've never seen him looking at his watch so that he can do some work. He's in Guwahati. And by 5 o'clock, if you ask him, he can tell you everything. How much sales, how much procurement, how much people were working, how much people are absent, what is productivity, what is his bank balance. Every millimeter of information he can give me. I can tell you, last over 30 years I know him. I've never seen him working. I've never seen him sitting in the shop and then taking stock of the of managing a business. So therefore, people are strange. It's a strange world and it's a complex world. A lady coming and saying that I can have a shop, and the court rejects the point. And this is only one point. Yeah, the rejection of the bona fide requirement is only on the ground that he had a trade license, and therefore there is a presumption she is doing good business. And the second is that she had no experience, past experience. But I've not read it completely. I'm just.
which is regarding trial court. Appellate court reversed.
No, reversal is there. That's why you are here.
Appellate court reversed.
So the dismissal of
So
the
far,
ground of bona fide requirement is
so
only
far,
that.
Defaulter part is concerned, I'll show that there is no default
Sure.
on the part.
But if one, what you call
goes-
no,
one
no.
in-
Out of many grounds, if one ground also is sustainable, then also you are liable to be ejected.
Yes.
Bona fide, even if it is there, because I found speeding when I'm reading, I don't have assistance. I don't know whether I'm reading right or wrong. But when I'm reading it, I found that the ground taken is that you gave a advance, some amount of advance was adjusted,
80,000
and then
and
some
20
part was remaining, and
remaining.
therefore non-payment is not a default, but that is the ground taken.
No, another defaulter ground is taken by the appellate court is that I have not tendered the before depositing.
Okay, so what is your evidence?
I have not called for the NJ case from May 2007. Page 42. Whether the impugned judgment and decree have been passed erroneously without appreciating the materials evidence on record and are not sustainable in law. Before I proceed with the merits of the appeal, what has been emerged at outset is that all the decisions rendered by the learned court have been assailed in the memorandum of appeal as well as in course of argument put forward by the learned counsel for the appellant. That being so, let me proceed to find out as to whether the learned trial court decided the issue in proper perspective in the light of the legal fact and materials on record or not. To see the legality and propriety of the decision rendered by the learned trial court, I find only one vital point required to be considered in this appeal as to whether tenanted premises is bona fide required by the appellant plaintiff for her own use to run the business thereon. This point pens round the issue number 4, 5, 6. These issues are revolving the question whether the appellate plaintiff refused to accept the monthly rent tendered by the respondent defendant, whether the respondent defendant is a defaulter in respect of payment of monthly rent in respect of the tenanted premises, and whether the respondent defendant is liable to be ejected from the tenanted premises which bona fide required by the appellant plaintiff. The suit is confined with the room out of 4 rooms comprising area so and so, forming a part of extreme western side of CI sheet roof Pakka Assam type house standing on a plot of land measuring about 5 lakhs covered by so and so under Beltala Muja within Guwahati Municipal Corporation ward number so and so in the district of Kamrup, Assam, and bounded by north land of the plaintiff, south land of the plaintiff, east land of Sri Mohesh Rai and Sri Dipankar Rai. My lord, this schedule is very much essential, my lord, because he said she has no other plot area. In the schedule, kindly see in the south land of the plaintiff, north land of the plaintiff. As
No, you see, it is your case that she has a plot of land let out to many tenants, and therefore it's not a bona fide requirement. So if in the north of the suit house, it's a land of the plaintiff, what is wrong in it?
No, she said that she has no other
plot of land.
Plot of land to
So you see, if
run the business.
No, it's okay.
To run the business.
This is about the plot of land, not about the area in her land. She's let out to somebody. She doesn't want him to go. For example, look behind. If Mr. Varun Dega is the tenant of X, they will not like to throw him out.
No, she filed against all.
No, it's okay, but I'm just giving an example. Mr. Dega was here. I can take his name, and therefore I'm taking it.
Admittedly, there is no dispute between the parties regarding tenancy. Plaintiff appellant in her plaint as well as in her evidence on affidavit stated that she has decided to run the business in the tenanted premises. And for that purpose, plaintiff appellant on 11/8/2006 has served advocate notice to the defendant respondent with a request to vacate the tenanted premises. After receiving the said notice, the month of August 2006, defendant respondent has paid the monthly rent to the plaintiff appellant. On the other hand, the defendant appellant in his written statement and in the evidence on affidavit has stated that in the month of July 2006, plaintiff appellant refused to accept the monthly rent tendered by the defendant respondent. As a result, defendant respondent has been depositing the monthly rent in court. But during his cross-examination, the defendant respondent has stated that he cannot remember the date on which tendered the rent for the month of August 2006 to the plaintiff appellant. He has also stated that he did not tender the rent for the subsequent month of the plaintiff appellant. It is not required also for subsequent month.
Not required.
Subsequent month,
No, no. The law,
tender.
the decision of this court is that once there is an animosity, and then only you are exempted for not tendering.
No. Once tender has been made, then started depositing. Subsequent tender.
No,
Not-
that is in context of a judgment of the Supreme Court in case of Uttar Pradesh. But it was not dealing with in that
Each and
decision.
every month tender is to be made.
Every month it has to make. This is our judgment, and it gives only one exemption. There is only one stray judgment in the JLT, where it says that once the plaintiff can show that there was, the tenant can show that there was acute animosity between the two, then only you are exempted, because otherwise the fear is that if the landlord and tenant are in quarreling circumstances, he goes there, he'll make out another case that he has come and threatened. Therefore, he says that once there is an animosity, that animosity is not here.
Not here, but once he issuing notice, whether issuing notice that you evict the suit premises and the term your tenancy has been terminated.
No, I don't know. At least if you can show me some citation, that is something else. But I don't know of one of any one of that. I am not aware of it. And I have an exemption not to know the law. You know that? I'll show you. I am statutorily exempted from knowing law. See this. In a country, everybody is required to know law. Not knowing of law is not an excuse. But I am out of this. I have an exemption not to know the law. This is Evidence Act. Look, 56, 57. What to take judicial notice? Facts of which judicial
Facts of
notice.
which court must be.
Now turn to the next page. I have given a pencil mark last where your hand is. Provided that. There's a pencil mark, I think. Last, provided that. Same page. No. Next page, last. Second proviso. Provided that. You turn next page. 13 items are there. After 13 items, you will find this second paragraph.
If the court is called,
Huh.
if the court is called upon by any person to take judicial notice of any fact, it
Court
may
may refuse to do so.
do so unless and until such person produce any such book or document as it may be considered necessary
Yes.
to enable it.
So if you tell me that this is a law, I can say that I don't know the law and therefore you will have to produce a book before me. So I'm the one exempted from knowing law. But it is, there are two things. The first argument you made was about that requirement of not giving the, not producing the, not producing the, not calling for the NJ records of May 2007 onwards.
Yes, it is subsequently after May
No,
2007.
but that again, there is a judgment of this court which says that even during the pendency of appeal, it will be your duty to show that this is not a defaulter.
Subsequent development.
Subsequent development also.
Subsequent.
So even in subsequent stage, it's the onus of the defendant, the tenant to prove that he is not a defaulter even in the pendency of the appeal. So there is, I don't find anything incorrect. So the only point is that how much time you will need to vacate it. Because you see, come below at paragraph 15 also.
In the present
The
case,
defendant fails to show by adducing material evidence that he has deposited the rent in court in respect of tenant premises after compliance of mandatory provisions of section 5(4) of the Urban Area Rent Control Act.
On the other hand, the appellant plaintiff during cross-examination has clearly deposited that she cannot, whether the plaintiff respondent defendant is depositing the rent in court or not.
She does not know. She has not received any notice. She does not know.
Notice she received.
No, I don't know, but that is that is what is there.
Even still, the payment is making in the court. That of course not in record. My lord, I will produce two judgment regarding one bona fide requirement and another is regarding the amount which is still lying with the plaintiff, the advance amount. In that case, it may not be treated as defaulter. (1989) 2 SCC 686. And 1988 3 SCC 131. 1988 3 SCC 131.
Just 1998 3 SCC.
1989 two judgment.
First is
1989 2 SCC.
1989 2 SCC
686.
686. Second one.
This is regarding advance money. If there.
Second one.
Second one is 1988 3 SCC 131. This is regarding the bona fide requirement. Paragraph 10.
Just now. Yes, what does it say, that decision?
Regarding 88 3 SCC, paragraph 11. Statute enacted to afford protection to the tenant from eviction on the basis of contractual right of the parties make the resumption of possession by the landlord subject to satisfaction of certain statutory conditions. One of them is the bona fide requirement of the landlord, variously described in the statute as bona fide requirement, reasonable requirement, bona fide and reasonable requirement, or as in the case of the present statute, merely referred to as landlord requires for his own use. But the essential idea basic of all such cases is that the need of landlord should be genuine and honest, convinced in good faith, and that further the court must also consider it reasonable to gratify that need. Landlord's desire for possession, however honest it might otherwise be, has invariably a subjective element in it, and that the desire to become a requirement in the law must have the objective element of need. It must also be such that the court considered it reasonable and therefore eligible to be gratified. In doing so, the court must take all relevant circumstances into consideration so that protection afforded by the law of the tenant is not rendered merely illusory or withheld down.
Yes. This this Ramdas. I'll show you something here. Three paragraphs I'm marking. So you've already marked it. The paragraph 15 which you have marked is required to be read with paragraph 13. Paragraph 10, 13, 14, and then 15 which you have marked. Just look at the paragraph 13. Yes, paragraph 13 gives a reference to the section 15.5.
Section 15.5.
And it says that the High Court had power to revisit the legality of the bona fide requirement and others in revisional jurisdiction. That jurisdiction we are lacking. This High Court is lacking. 15.5 is not there in the Assam Urban Area Rent Control Act. That is number one. And second decision you see, the second citation you gave us, 89 to SCC.
That is on the pretext of TP Act.
Huh?
Transfer of property.
No, that is in context of, you have that judgment.
Yes.
You look at this judgment, there you will find reference to Andhra Pradesh Building Rent Control Act.
Yes.
You know the uniqueness of Andhra Pradesh Rent Control Act. Section 7(2) says of that act that once there is an agreement for the rent, apart from the statutory rent, the landlord is not entitled to take anything more. Therefore, advance premium, those are deprecated in this judgment. Seven two is a situation which is not available in the Assam Urban Area Rent Control Act. I'll give you this because this is something I opened. I triggered the memory and therefore I have found this. Into class. This is 7(2) of the 7 of the Andhra Pradesh Building Rent Control Act. 2 you see. Please read that so that I'll remember it again.
Where the fair rent of the building has not been so fixed, the landlord shall not, after the commencement of this act, claim, receive, or stipulate for the payment of any premium or other like sum in addition to the agreed rent.
Correct. So that is the legal requirement. There you can't have an advance. So once this defaulter also decided against you, you don't find there's any requirement of interference with the appellate judgment. So, Mr. Sharma, we give him 6 months time, but then he will vacate the house with 6 months time. And for that 6 months, we'll have to pay additional rent. It's in GS Road. GS Road, the rent would be high. You have to pay a very high rent. For the 6 months you will be holding, you'll have to pay 10,000 per month at least. Just ask me those cases, both the cases.
What for us?
In your case, Mr. Ghosh, was there an agreement?
Yes.
Where is that agreement?
Translated to PM. Because there was earlier order for submitting translated.
Heard Mr. S.K. Ghosh, the counsel for the appellant, sorry, petitioner, and Mr. A.C. Sharma, the senior counsel, assisted by Mr. B.C. Talga, counsel for the respondent. Next, for by filing this revision under section 115 CPC, read with Article 227 of the Constitution of India, the petitioner has assailed the appellate judgment and decree dated 1/3/2013, passed by the learned civil judge number 1, Kamrup Metro, Guwahati, in title appeal number 91 of 2010. By the said appellate judgment, the appeal was allowed. The appeal of the respondent landlord was allowed by setting aside the judgment and decree dated 22/7/2010, passed by the London Court of Magistrate number 2, Kamrup Metro, Guwahati, thereby by which the suit or eviction filed against the petitioner that dash tenant was dismissed. Next. The respondent is the landlord of the petitioner in respect of the suit premises page 18. Schedule B, which is described in Schedule B of the plaint. The along with the tenant premises, the respondent had also constructed the land of the petitioner and land of the respondent consisted of construction of 4 rooms, out of which one room is the suite premises described in Schedule B, and pursuant to an agreement between the parties dated 1/3/2001, the petitioner had taken the suite premises on rent, agreeing to pay rent at the rate of rupees 1400 per month. Full stop. The tenancy was in accordance with the monthly English calendar basis, and the tenanted premises was used for carrying out business under the name and style of Mrs. Chandika CHAN DIKA Glass Agency. As per the agreement, the rent became due, monthly rent became due within the first week of the succeeding month. The other 3 rooms of the respondent was let out to 3 separate tenants. The plaintiff is positive that in all, the respondent was receiving a monthly rent of rupees 3,600 per month for the 4 rooms, which was insufficient, and therefore she had decided to start a business of stationery cum gift item from the suite premises. So it was also projected that the respondent was facing financial hardship, and that to start the business, she had obtained a trade license from the Guwahati Municipal Corporation on 18/8/2006 for operating the business under the name and style of Mrs. Deepti's DIPTI ' near NWR, and had arranged for money from taking loan from her relatives. On the ground that she had no other premises, alternative premises in a commercial locality, suit for eviction was filed against the petitioner by citing cause of action which had arose on in the month of June 2006, 11/8/2006, and 24/8/2006, which is elaborately described in the plaint. The appellant had contested the said suit, filing written statement and taking a plea that the respondent did not require the suit premises bona fide, and it was denied that the respondent had decided to start a business of stationery cum gift items and had obtained trade license from the Guwahati Municipal Corporation. The petitioner had denied that any cause of action took place on the dates stated by the respondent, and had also taken a plea that the respondent landlady had taken an amount of rupees 80,000 from the petitioner by as an advance, which was agreed to be deducted at the rate of rupees 200 per month, which was later on increased to rupees 400 per month as adjustment, and that till 1/3/2006, a sum of rupees 24,000 had already been adjusted, and a balance advance of rupees 56,000 was still lying with the plaintiff, with the respondent. And that since July 2006, the respondent had refused to accept rent from the rent lawfully tendered by the petitioner. And description of Miss within bracket NJ, case details were pleaded of deposit of rent of rupees 1,000 per month in court by those NJ cases. But for the plea of the petitioner is that that apart from 4/5 Assam type house mentioned in the plaint, apart from the tenanted premises, the respondent had 4/5 Assam type houses apart from those mentioned in the plaint in her compound, which was let out to different families. And the son of the respondent was a builder who was earning enough to maintain himself and his family. And that the respondent was a housewife and it was not possible for her to do business. Next paragraph. The learned trial court, on the basis of pleadings, framed the following issues for trial. 32. 6 issues for trial. This one. Can you tell me how many witnesses were examined by the plaintiff? Only one witness. Because in the trial court judgment, we don't find any reference to those witnesses examined. It's not the what they call discuss the other PWs or
I think one PW, one DW.
only one PW, one
DW1.
PW. The next paragraph, the learned counsel for the petitioner has submitted that during trial, the respondent landlady examined one witness, examined herself as the sole witness for the plaintiff, and seven documents were exhibited. And exhibited
Nine documents.
nine documents. Nine documents. The death certificate of the husband within bracket exhibit 1. Title deed. There's no exhibit 2. Exhibit 2. Keep a gap for exhibit 2. Title deed is exhibit 3.
Exhibit 2 is trace map.
Trace map. Okay. Trace map, exhibit 2. Then
Exhibit 1 is death certificate.
a death certificate of the husband. The 3 is title deed, exhibit 3. Mutation certificate
Exhibit 4.
within bracket exhibit 4. Land revenue paid receipt exhibit
5.
5, 6,
6 municipal tax.
5 municipal tax within bracket exhibit 6. Seven, give a gap. So 7 is a trade license within bracket exhibit 7. Advocate's notice within bracket exhibit 8. And advocate's reply within bracket exhibit 9. Full stop. The petitioner dash tenant exhibit himself as PW1 and exhibited the following: agreement within bracket exhibit A, money receipts, exhibit B within bracket 1 to 53, NGK's challans within bracket exhibit C within bracket 1 to 43, and NJ cases, record of NJ cases within bracket exhibit D within bracket 1 to 13. The learned trial court, upon examination of the materials available on record, held in respect of issue number 1 that that in absence of specific materials, the suit was maintainable. In respect of issue number 3, it was held that the suit was not bad for non-gender necessary parties. In respect of issue number 4, it was held that a sum of rupees 56,000 was lying with the respondent entity, and therefore, as it was not adjusted towards rent, the appellant is not a defaulter. Not appellant, petitioner, not a defaulter. And resultantly, the learned trial court also justified the non-payment of area rent. Also justified the lack of prayer in the plaint for claiming area rent. In respect of issue number 5, based on the GMC trade license within bracket exhibit 7, the learned trial court arrived at the finding that the respondent landlady was running her business, and moreover, took notice of the fact that exhibit 7 was not renewed, and relied on the cross-examination of PW1, wherein she has stated that she had no experience of business. It was held that the need of the plaintiff for the suit premise is not genuine, and that the suit premises were not required by the respondent. In respect of issue number 2, it was held that the respondent plaintiff had narrated a bundle of facts but failed to establish that the petitioner was a defaulter or that the suit premises was required by her. And as the respondent was not entitled to any relief, therefore, it was held that the respondent had failed to prove any cause of action for the suit. Full stop. Resultantly, in view of decision on issue numbers 2, 4, and 5, the issue number 6 was decided in the negative by holding that the respondent was not entitled to any relief, and the suit was dismissed. Next paragraph. The aggrieved respondent preferred an appeal which was registered as title appeal number 91 of 2010, which was adjudicated in the court of the Honorable Civil Judge number 1, Kamrup Metro Guwahati. The learned appellate court on the basis of materials available on record formulated the point of decision as follows: dash whether the impugned judgment and decree have been passed erroneously without appreciating the material evidence on record and are not sustainable in law. Next paragraph. The learned trial court, learned appellate court had revisited the pleadings as well as the evidence on record and considered the fact that after receiving the notice, the advocate's notice for eviction since the month of August 2006, the petitioner had not paid monthly rent to the respondent. First, the court also took notice of the cross-examination of the petitioner, wherein he had stated that he cannot remember the date on which he tendered the rent for the month of August 2006 to the respondent. And he had also stated that he had not tendered the rent for the subsequent months to the respondent. First, therefore, moreover, the court also took notice of the statement made by the petitioner that he had not called for the records of NJ cases after May 2007. The court, the said learned court by referring to the case of page 44, blue pencil. Held that the petitioner had failed to show by adducing any material evidence that he had deposited rent in court in respect of the tenanted premises after compliance of the mandatory provisions of section 5 within bracket 4 of the Assam Urban Area Rent Control Act, 1972. And in view of the statement made by the respondent in her cross-examination that she cannot say whether the petitioner was depositing rent in court or not, held that the learned trial court had committed grave error in arriving at a decision in issue number 4 that the petitioner was not a defaulter, and accordingly, the said finding of the learned trial court was reversed by holding that the petitioner was a defaulter. Full stop. The next point of whether the respondent had a bona fide requirement of the suit premises, comma, the learned, the appellate court took notice of the pleadings and evidence to the effect that as the pleadings of the respondent, that the monthly rent of 3,600 per month was insufficient, and therefore she had taken permission from the Guwahati Municipal Corporation on 18/8/2005 for running her business under the name and style of Mrs. Deepti DIPTI near NWR, and that she had no other alternative premises within the Guwahati city except the suit premises. It was held that the tenant premises was bona fide required by the respondent to run her business. Full stop. In this regard, referring to the trade license within bracket Exhibit 7, it was again reiterated that the requirement of the suit premises was bona fide, genuine and honest to run her business. In this regard, reference was made the case of page 46, Srimati Arati ARATI Saha versus Sri Mangal MANGL Sarkar, 1990, within bracket 1995, bracket was 3 GLR 221. Resultantly, as the issue of bona fide requirement and the defaulter was decided against the petitioner, the appeal was allowed by reversing the decree of dismissal of suit, which was passed by the London Trial Court. Next paragraph. Receiving the appellate judgment impugned this appeal, the learned counsel for the petitioner had referred to the pleadings on record, and it was submitted that in respect of the issue of defaulter, balance sum of this 56,000 was lying with the respondent, and for which the petitioner was not a defaulter.
And cross-examination also admitted.
And in this regard, the reference was made to the cross-examination of the PW1, where she had admitted the said amount lying with her. Full stop. The
another admitted, I refuse to take rent as defendant did not vacate the suit premises.
Okay, and no, that is for defaulter.
Defaulter.
This is we are now on the
Bona fide requirement.
no defaulter. We are not defaulter.
Yes, that is
Oh,
why
acha, okay.
I refuse to take rent as
The
dependent.
Learned Counsel for the petitioner has also referred to the that part of the cross examination of PW1, wherein she had admitted that she did not accept the rent as the uh, as the petitioner was not vacating the suit premises. Full stop. In said context, next paragraph, in said context, the tenancy agreement between the parties has been perused. Full stop. The learned counsel for the petitioner has provided an English translated copy of the said agreement for the convenience of the court. Full stop. From clause 2 of the said agreement, it appears that the parties had agreed that out of the that the petitioner had paid a sum of rupees 60,000 to the respondent as advance for repairing of the shop and agreed to pay a further sum of rupees 20,000 as advance. And out of the total advance of rupees 80,000, the parties had agreed that a sum of rupees 200 per month shall be adjusted from the monthly rent. And after adjustment of the remaining balance amount shall be kept as security at the time of termination of tenancy, and the respondent was required to refund the security amount to the petitioner on termination of tenancy. Full stop. The said agreement does not contain any clause that the outstanding advance which remains with the respondent shall be adjustable against the rent. Full stop.
200 shall be adjustable.
Huh?
200 rupees.
No, that's what I'm saying. That it will be adjusted against the entire rent. That is not the agreement.
Not the, only 200.
Only 200. That's what I'm saying. Adjustable to the entire monthly rent. First, the finding of fact recorded by the London trial court, by the London appellate court, first appellate court, is to the effect that there was an admission by the petitioner during his cross-examination that he cannot remember the dates on which he tendered monthly rent for the month of August 2006, and that he had also admitted that he did not tender the rent for the subsequent months to the respondent. Full stop. In said context, it may be appropriate to refer to the provisions of section 5 within bracket 4 of the Assam Urban Area Rent Controls Act, which is extracted below. Next paragraph. The judicial pronouncement of this court, as well as the Supreme Court of India on the, in light of section 5 within bracket 4 of the Assam Urban Area Rent Control Act, is that the deposit of rent in court was permissible only on refusal of the landlord to accept the same. And that the deposit, and that the tenant is required to deposit the rent in court, which must be made within a fortnight of its becoming due. Moreover, the mandatory procedural requirement of the deposit is that the tenant has to file written up notices to be served on the landlord, which is required to be accompanied with the requisite process fee for service. Full stop. Nothing has been brought on record to show that the said well settled principle regarding section 5(4) of the Assam Urban Areas Rent Control Act, 1972 has been diluted. Full stop. Next, in support of his submissions that when an advance was available with the landlord, the tenant would not be a defaulter, reliance has been placed in the case of Modern Hotel, Gudur, GUDUR, versus K. Radha Krishnaiah, RADHA, KRISH, NAIAH, and others. First, in the considered opinion of the court, the said case would not help the petitioner to espouse his cause because of the fact that the said decision was rendered having regard to section 7 within bracket 2 of the Andhra Pradesh Building within bracket lease, rent and eviction bracket closed, Control Act, 1960. The said provision is quoted in paragraph 5 of the said judgment. It shows that the landlord is prohibited to accept any sum in excess of the agreed rent. And therefore, in light of the said provision, the said case was decided. First of all, in the present case in hand, there is an express agreement between the parties that any amount of excess, any amount of advance lying in excess of adjustment would be treated as security deposit. First of all. Therefore, in the absence of any stipulation that any adjustment in excess of ₹200 from the monthly rent was permissible, the decision of the Learned First Appellate Court cannot be faulted with. For the others, I can excuse all of them because I won't have time to take up. There is one matter which is your matter, which has to be addressed. I think we'll postpone it for some other day. Mr. Chakravarti.
He is here, my lord. He has taken the instructions, I think.
Okay, but since I'm dictating, you can wait for some time if you want to wait. Others may leave because I won't have time to take up any other matter.
And I have a matter my lord, interim order reporting.
Just tell the court master, give a slip to the court master. Mr. Ghosh and Mr. Sharma, what is that judgment? Abdul Motin Chaudhary. He says that the liability to rent, to continue to pay rent continues even during the pendency of case. What is that? In the context of Assam Rent Control Act, especially section 5 within bracket 4 thereof. Which is the suggestion? Which case? Comma. The provisions of the said provisions has been interpreted by the court in the case of Shobha Biswas, SOBHA, Biswas, BISWS, and others versus Ranjit Lodh, comma, 2006, within bracket 1, bracket close, GLT 479, wherein the division bench of this court had held that the liability to pay monthly rent to the landlord subsists during the pendency of eviction suit, even though the default relates to a period after filing of the eviction suit. And it was also held that if a tenant fails to discharge his liability, comma, the landlord shall have the right to get the decree for ejectment. The said salutary interpretation of the of section 5 within bracket 1 and 5 within bracket 4 of the Assam Urban Area Rent Control Act, 1972 has been followed in a large number of cases. Next paragraph. On the issue of bona fide requirement, comma, it is observed that the learned trial court had rejected the bona fide claim of bona fide requirement of the respondent on the ground that the respondent had already obtained a trade license, and therefore there was a presumption that she was doing business. Full stop. In the considered opinion of the court, comma, such a presumption is not available to be taken by the learned trial court. Because GMC Act. GMC Act. Just see the provision I have forgotten. Trade license, you get it in the trade license. What is the provision for trade license? It will be there, 337 or something. I forgot those sections. Into section. In the trade license, you'll get that under section so and so. Provisions are given. Uh, 180. Because under the provisions of section 180 of the Guwahati Municipal Corporation Act of 1971, there's a requirement of taking a license annually for carrying out any of the professions, trades or calling indicated in the 4th schedule. And the legal requirement is to take a license before the 1st day of April in each year or within 1 month of his taking up the profession, trade or calling. Therefore, there is no bar, there is no express bar under the Guwahati Municipal Corporation Act from obtaining a trade license prior to commencement of the business. Full stop. Next panel. The learned trial court has rejected the bona fide requirement of the respondent on the ground that she had no experience in doing business. Full stop. The said finding, in the considered opinion of the court, is without any basis, because there is no legal requirement that one must have an experience of business and then venture into a business. Full stop. There is not a mandatory requirement of law that before commencing a business of his own, a person must mandatorily work as an apprentice, which would be a qualifying prerequisite for doing a business. Therefore, there cannot be a legal presumption that merely because a person is an aged person or that he or she has no experience in doing business, there would be a presumption operating against such person that he or she is quite incapable of doing business. So much so that the bona fide requirement for the premises would fail. Full stop. Therefore, in the considered opinion of the court, the finding written by the learned First Appellate Court appears to be in a sound premises, and that the interference with the finding of the learned trial court on bona fide requirement is held to be justified and is upheld and is affirmed. Next paragraph. In connection with the plea of bona fide requirement, in support of the submissions on bona fide requirement, the learned counsel for the petitioner had placed reliance on the case of Ram Das RAM DASS versus Ishwar ISHWAR, Chandra CHANDER, and others within bracket 1988 3 SCC 131. First one. The said decision also does not appear to help the petitioner in any manner. First off, the said decision was rendered in the context in the background of interpretation of section 15 within bracket 5 of the East Punjab Rent Restriction Act 1949, which enabled the High Court to satisfy itself as to the legality and proprietary proprietary of the order under revision, and it was held that the said provision gave a much wider jurisdiction which enabled the court of revision, in appropriate cases, to examine the correctness of the findings of facts also, though the revisional court is not, inverted commas, a second court of first appeal, inverted comma closed. Full stop. The said enabling provision is not available to this court under the provisions of Assam Urban Area Rent Control Act, 1971. Full stop. Therefore, the jurisdiction of the court in exercise of divisional jurisdiction is only to examine if the examine under section 115 CBC as to whether the learned courts below had exercised a jurisdiction not vested in it by law, or failed to exercise a jurisdiction so vested, or had acted in exercise of its jurisdiction illegally or with material irregularity. The said scope, in the considered opinion of the court, cannot be expanded to revisit the facts and to arrive at a conclusion, which is which according to the court would be appropriate. Full stop. Next paragraph. Therefore, comma, in the touchstone of the provisions of section 115 CPC, comma, the court finds that the court is inclined to hold that that in light of discussions above, comma, the decision of the appellate court appears to be in a more sound footing than the decision rendered by the learned trial court, because the learned trial court, comma, on the basis of surmises and conjectures, arrived at a decision that the respondent did not have a bona fide requirement of this for the suit premises. Next paragraph. The court has the power and jurisdiction to take note of the ground reality, which is that the suit property is situated in GS Road of Guwahati, which is one of the very high value commercial region, and the price of the properties would be much higher than any other place in the state, in the city. Full stop. The said factor is only for the purpose of examining whether the proposed venture of the petitioner of the respondent could be started in a place like that, and therefore, as the property is a commercial property, is in a commercial area, the court does not find that the idea of the respondent to start a business to augment her income is not at all justified. Full stop. Next part. Next one, continue. First of, therefore, comma, the court is inclined to hold that the bona fide requirement which existed at the time of filing of the suit would still continue, as the area in which the suit property is situated has a potential of establishing a business, reasonable business venture. Next paragraph. Therefore, comma, the revision is found to be devoid of any merit and the same is dismissed. Next paragraph. Considering the fact that the petitioner has been doing business from the said suit premises from the year that agreement is here, from the year 1/3/2001.
Not prior to that also.
Just tell us when. As appears from the agreement between the parties.
Agreement 2020, 2001.
The court is 1.3.
1.3.
That's what I mentioned. 2001, comma, the court is inclined to grant about 6 months' time to the petitioner to vacate the suit premises.
Can it be
No, we can't extend that. 6 months.
at least 9 months?
No.
Because I'll have to take alternative.
No, we can't extend that. 6 months, ending on September, October, November, December, January, March, ending on 31st March 2023. Full stop. Or 2024, right? Full stop. For the said extended period, comma, the occupation of the tenanted premises till the said extended period would not confer any right to the petitioner to and such occupation shall also not be construed to be a fresh tenancy. Full stop. For the said for the months of October 2023 due to March 31st March 2024, comma, the petitioner shall have to pay a monthly rent of rupees 10,000 per month. Not rent. What is it called? Compensation. We will pay compensation to the petitioner for the responding to the extent of the 10,000 per month. So if such compensation is not paid within 7 days of the next month, comma, right would rest on the respondent to put the decree into execution. Stop. On such payment be tendered, comma, the respondent shall issue a money receipt. Next paragraph. In order to facilitate the respondent, the petitioner to stay in the.
I'll pay through bank draft. Bank draft.
Whatever you pay now, they acknowledge it.
Because suppose she is not accepting.
We'll say, we'll make it easier. Pay within 10 months, for which the respondent shall provide her bank account details, to which the petitioner shall deposit the compensation by wire transfer.
Bank account gets to home.
Huh?
Bank account gets to home.
You give it to him or to the tenant, whoever you desire. Or GPay or everything. Nowadays, you don't have to worry about anything. Even the vegetable vendors now operate with Google Pay. The bank account also Google Pay or any other electronic transfer mode, electronic money transfer mode. In order to facilitate the petitioner to overstay in the suit premises till 31/3/2024, the petition shall be required to submit an undertaking before the learned trial court that he would be vacating the suit premises on 31/3/2024 by handing over possession of the suit premises to the respondent and no one else. Full stop. The undertaking shall also to be the effect that he would pay compensation, monthly compensation to the respondent to the extent of rupees 10,000 per month from October 2024 to 1st October 2024 to 31st March 2024, And that during the said extended period of stay, comma, he would not make any alteration, modification of the suite premises, nor introduce a third party into the suite premises or in his business, or create any third party rights. Next paragraph, on failure of the petition to hand over the vacant position of the suite premises described in the plaint to the respondent, comma, it would be open to the respondent to put the or in case of violation of any of the terms imposed by the court, comma, it would be open to the respondent to put the decree to execution. Yes. Anything I've left out? I've touched ejectment after a long time.
One prayer, my lord. If they want to make a fresh agreement with me, in
No, that I won't say. That you and Mr. Sharma, Mr.
Yes,
Ghosh and Mr. Sharma would negotiate. It will not be a part of the order. Mr. Sharma, if you
because
no, you can still
on several
No.
occasions I
Mr. Sharma,
try to.
I'm saying it to you because I know you as a good negotiator.
Because only 5 lessons of land, they will also not been able to do anything. my lord.
That I don't know, but
And it will
Mr.
be
Sharma is
ultimately it will be go to the
no
Hotel
Mr.
Star
Ghosh,
Line.
Here I don't have to
It
worry
is
because
adjacent plot of Hotel Star Line.
no, I'm not saying anything. You see, because of the
5
fact that
lessons of land, they will it.
no, I'm not on that. What I'm saying is that knowing you as I've known and Mr. Sharma, I think if you can both sit together, it will be negotiated.
Even by enhancing the rent more also,
Piece of powder, an invitation. Mr. Sharma, please look into it if you can. If you can use your skill for a negotiated settlement. Yes.
My lord, item 57, it is of some extreme urgency. I pray for only notice, my lord. There is a delay condonation petition. Because, my lord, the decree, judgment and order has been passed apparently ex parte against the petitioner under section 6 of the Specific Relief Act. So I pray
This is a condonation application.
Yes, my lord. I pray for notice on this.
Okay.
Item 57, my lord.
67.
57.
57. Okay. Mr. D.P. Bora, counsel for the applicant. Application under section 5 of the limitation act. Notice steps within 2 days.
Yes,
Returnable on.
My lord, can it be before the vacation, my lord? And I may be permitted to take justice service also, my lord.
Dusty also.
Yes, my lord.
Okay,
Because the
Dusty.
execution proceeding has been started, my lord. Summary procedure, my lord.
Dusty. To be written through the registry of the court and upon service and affidavit of the service shall be filed. List on 11/10/2023.
Obliged, my lord. 11 or the next week, my lord. Because 11 will be too early, I think, my lord.
No, next week, you see, we will be having Puja Rush.
Yes, my lord.
All the platforms in the station would be
13,
overbooked with a
Yes, ma'am.
lot of incoming train.
Yes, 13/10, my lord.
13.
13, my lord. Because 11 will be, I think, too early, my lord.
No, all these weeks will become motion day. We are very apprehensive.
Yes, my lord. Or, my lord, it may be after
Okay.
vacation also,
No,
your
no.
lordship.
This is from which place?
Nalbari, my lord.
Nobody, you can go and bring it.
Yes, my lord.
Because I'm avoiding last week. So it will be very difficult times for us.
Yes, my lord. Yes, my lord.
Let it be 12th.
Yes,
We're giving you one more day's time. 12th.
Yes, my lord.
12/10. Okay.
Obliged, my lord.
Because you see, we have to, all this week, we have to sign all the orders and then
Yes, my lord. Yes.
it becomes a very difficult task at times.
And now the petitioner is also, because the execution proceeding has
No,
started.
I'm not difficult in giving this, but this puja time.
Yes, my lord, I understand.
Very
Deeply
difficult times
obliged.
for us.
Deeply obliged, my lord.
Very difficult times for us.
Yes, my lord.
And you know, Mr. Bora,
Yes, my lord.
there is another difficulty. Because the matters which are listed are not being, people will take adjournment. And that again is a burden to the entire system.
Yes, my lord.
Matters are listed, so because of listing of some matters, the other matters which has urgency are not listed. So everybody is dissatisfied. People, the lawyers whose matters are listed are dissatisfied. Lawyers whose matters are not listed are dissatisfied.
Yes, my lord.
And while working the entire court staff, which is my support staff, they are dissatisfied because every order has to be signed and released. So
Obliged,
yes, Mr. Hawk, what is your instructions? That will be better because any observations of the court would go drastically against you. But I'm giving you liberty to come back if required. You're giving him liberty this time.
My lord. Lordship may give liberty, but Lordship may record my submissions if Lordship pleases. Otherwise, that's up to your
No,
Lordship.
we are not doing it. Once he's withdrawing it at this time, we are not saying anything adverse. We are not saying anything adverse. But we only refer to your objection. We
My
just say preliminary on the question. We are not saying anything more. Because once he makes that prayer, he comes into the genuine lawyer category. We're not taking any. This is item number 8 and 9, right? Separate orders. At the outset, Mr. T. Chakravarti, learned counsel for the respondent number.
The private respondent, my lord, in respect of item number 8, respondent number 3, 5, 6, 7, and 9.
3, 5, 6, 7, and 9.
And in respect of the other matter, my lord, respondent number 4 and 5.
4 and 5, huh? Duta Bregle. Okay. Has submitted that he has raised a pending issue of maintainability in this case. Full stop. Next paragraph. The Mr. S. Hockland, counsel for the petitioner, upon instructions, praised to allow him to withdraw the petition with liberty to approach again, if so advised. Full stop. Notwithstanding the objection made by the then counsel for the private respondents, the prayer is allowed. The writ petitions are permitted to be withdrawn with liberty to approach again, if so advised. So this is next date we'll fix when. Anything else is required here?
Item number 7, Your Lordship, everything is completed. Item number 7, the pleadings are completed today, Your Lordship. My senior had.
Items are completed. Items is item 7.
Item 7.
Item 7. Heard Mr. M. Sharma and Mr. D. T. Chakravarti, the counsel for the petitioner. You're for the petitioner?
I'm not in the item somewhere. I'm not there, my lord.
Oh, so not there. Okay, then only Mr. M. Sharma for the petitioner. Also had Mr. A.C. Barbara, counsel for the
respondent number 8.
The senior counsel, assisted by Mr.
M. Smith. M. Smith.
M. Smith.
M. Smith.
Counsel for respondent number
8.
8.
Private respondent 8.
Mr. S. Hawk, counsel for respondent number 5. And Mr. S. Barwa, that is standing also for respondent number 2 and 3. So the arguments are concluded, judgment is out.
Patience hearing, really applies. Yes. Hard.
At length.
At length, my lord, irrespective of the.
As a part of the, there's a duty I have to perform. I have to do it. Ms. Mazumdar. No, Mrs. Mazumdar, no, I have something else to tell you. Thank you for joining on that day in the deliberation. We are not taking up the matter in right earnest. We are trying to have few more consultations with the judicial officers and again the mediators, trained mediators. We really want to see that this thing restarts again.
Yes.
So if any inputs you have, please, in a form of note, give it to the court master
Yes.
so that we can, because right now,
Referral
Yes,
is very less, Lordship.
the mediation is not taking place in the entire state. If you can kindly make a note based on which we can chop out a plan.
At least even if one case per court is referred every day, even if High Court I'm saying, Lordship, then also many cases go to the mediation.
Oh, that's why. That's why. I would consider allowed it after transit.
Not final draft substitution method. There is some little difference method. And the government has approved this one, final draft substitution. And we go through this.
In the printed book and this, there's a.
Yes, madam.
They've given it to.
Final draft. Yes, yes.
This one.
Yes.
This had difference.
Yes, referred. Only one of the appendix 3 table 3. Appendix 2 table 3.
Okay, just write what is the difference here in that. Give a note, otherwise I'll forget. Does it have any impact of that? No, no impact.
Because you're not relying on the regulations per se, Your Lordship. We're
So
not,
our case is that regulation is not
we
applicable.
have predated the regulations.
We are.
That is,
No, not from your perspective.
yes.
But from the perspective of the alteration in the draft, will it have any impact?
Well, in that case, my lord. My lord, in that case, if they are.
No,
some-
it leads to a different
Yes, but I
connotation.
understand. Well,
You see, what will the connotation is that a draft is approved and then it is amended.
Yes.
So the effective acceptance of the 94th meeting is this or that?
Yes.
Final draft.
Is the final draft which is not this?
Not.
Okay, so just write in the top so that I remember. No, they are, you are there, all the council are there.
And just because it has been placed, my lord, they are saying, their case is that in the table 3, annexer 3, the qualification was not there in the draft which was presented to the government. Subsequently, it was modified or whatever, then it was brought into force. Had it been the case, they ought to have challenged the regulation stating that this
I'm
thing.
just saying, just write it down. Since I have closed my pen, I would not.
They-
Even if you say so many things, I would not retain anything. Once my files are closed and packed up.
The Lordship has many stories to go through. It is one story that we have to address. So that is
No,
primarily
not
slightly
that.
easier for me that way.
When the file is shut down, I am
Yes,
completely shut
absolutely.
down.
The Lordship has
So
given us
therefore-
enough ample
Therefore,
logins.
just write in a piece of paper. Give him a piece of paper.
So both sides.
Whatever you have to say, just write it down so that I would remember. Peter, after closing,
Yes.
doesn't waste.
Yes, yes, yes.